Team 302 and 304 are the finalists who will be competing. A is oralist 1, B is oralist 2, and C is the researcher. So each team comprises of 3 members.
Each team is?
Each team comprises of 3 members. 2 oralists who will be arguing the matter, and 1 is the researcher. So marking shall be done for 2 oralists 1 and 2. So the score sheets have been accordingly set. Good morning to all. I, Shraddha Mumaya, Associate Partner of Trans India Law Associates, welcome you to the 3rd edition of TILA International Moot Court Championship Round. I would like to congratulate all the participants who backed their position by their hard work and poise skills. I will be the moderator for this session. I request all the participants here to kindly switch on their video for the effective session. Please ensure that your voice is clear, you are audible to the respected judges. Please ensure that there is no movement in the videos. I would like to introduce our judges for the finale round. We have His Excellency Honorable Dr. Radhakrishnan, Chairperson, Tripura Electricity Regulatory Commission. We welcome you, sir. We have His Excellency Honorable Mr. Chaudhary, Member, Bihar Electricity Regulatory Commission. We welcome you, sir. We have Dr. Rashi Gupta, Managing Director, Vision Mechatronics. Welcome, ma'am. We have Dr. Ashish Nandan, Renewable Energy Expert. Welcome, sir. We have Mr. Deepak Dikshit, Associate General Counsel, Biorad Laboratories Private Limited. Welcome, sir.
Thank you.
We also have with us Ms. Archana Maharaj, Senior Associate, Trans India Law Associate, who is going to be the coordinator for the event. Welcome, Archana. We also have with us Bailiff Meenakshi. Meenakshi, can you please introduce yourself?
So I am Meenakshi Iyer. I am a law student from the University of Canberra, and I'm also working as a research intern with Trans India Law Associates. It is my honor to be a bailiff for this competition, and I'm looking forward to it. All the best.
Thank you so much, Meenakshi. Do we have all the participants from Team 302? Please confirm by saying yes. Team 302A?
Yes.
Team 302B?
Yes.
Team 302C?
Yes.
We have the participants now from our second finalist, TIMCEE, Team 304. Team 304A?
Present, ma'am.
Team 304B?
Present, ma'am.
Team 304C? Thank you so much, teams. We welcome the teams, the finalists, and both the finalists will be competing against each other. Team 304, who has entered into the finale round, and Team 302. Okay, so the teams that shall be arguing the matter from the appellant side is Team 304, and the team that shall be arguing the matter from the respondent side is Team 302. Now, I would request the bailiff to please take a note of the time allotment of both the speakers from both the teams. Each team shall have a total of 45 minutes. Team 304, can you please share your allotment time with us orally, and also you can type the same on the chat box.
Ma'am, speaker 1 will be taking 23 minutes. Speaker
Can you please be louder?
Ma'am, speaker 1 will be taking 23 minutes of this code, and speaker 2 will be taking 18 minutes, and we reserve 5 minutes for the rebuttal.
Thank you so much. Bailiff, have you noted it down? All right. Team 302?
Yes, ma'am. Ma'am,
How-
speaker one will be taking 25 minutes. Speaker 2 will be taking 17 minutes and 3 minutes for rebuttal.
25 minutes, 7 minutes, and 3 minutes for rebuttal.
Yes.
Sure. So the honorable judges, with your permission, can we please begin the round?
Please. Please. Please.
Thank you so much. So shall we start with Team 302? Team 304, the appellant side. Yes, you may begin. Your time starts now.
Good morning, Your Excellencies. If it may please the court, this is agent number 1, team TILA 304 on behalf of applicant United States of DGEF, along with my co-agent. Your Excellencies, I shall be speaking for first 23 minutes, dealing with the Issue 1 and Issue 2 prima facie deals with the jurisdiction of this Honorable Court and admissibility of the seat of arbitration as GEAC. Subsequently, my co-agent will be dealing with Issue 3 prima facie deals with the Your Excellency, we humbly reserve 5 minutes for the rebuttal. If Your Excellencies do not have any preliminary questions, the agent would like to proceed with the arguments, followed by a small brief of facts.
Okay, go ahead.
In present matter, there is a company named Targaryen Power Corporation Limited, established in the year 2001 in the United States of DGEF. There was a bilateral investment treaty signed between United States of DGEF and Union of TILA, as the main core of the treaty was to promote and make sure that the investments will be proper and equitable treatment of the investments in both the countries. As a result of the treaty, a contract was made between White Workers and Targaryen Power Corporation Limited. Bilateral investment treaty, which was signed in 1996, and an economic partnership agreement, which was signed in 2009, are the guiding principle of the contract. 7th March, WHO declared the world pandemic COVID-19, due to which an governmental clarification issued by the government of Tel Aviv, declaring force majeure clause as an force majeure, COVID-19 as a force majeure clause. From 10th April, the gas allocation was stopped for Targaryen Power Corporation Limited, due to which, as a result of which, a notice was issued, an arbitration notice was issued from the DGEF by Targaryen Power Corporation Limited to government of Tel Aviv, to which no reply has been came. As a result of which, an international proceedings notice has been issued by the Targaryen Power Corporation Limited against government of Tel Aviv. On this side, the claim that the seat of arbitration should lie in GEAC Global Energy Arbitration Center based in King's Landing, but applicant humbly submit that the seat of arbitration shouldn't lie in GEAC based in King's Landing because it wasn't mentioned in the Gazette of Tel Aviv. In order to protect the interests of its corporation, United States of DGEF brought this matter in front of this Honorable Court. With the prior permission of Your Excellencies, the agent would like to proceed to the arguments.
Okay.
Your Excellencies, before in front of this Honorable Court is about the jurisdiction of this court. Your Excellencies, the present matter fall under the contentious jurisdiction of International Court of Justice. Under Article 34, Paragraph 1, it is clearly mentioned that only state can be before this Honorable Court. Your Excellencies, however, a country can always represent its national, including corporations and individuals, provided that they could successfully avail the principle of diplomatic protection. For successfully availing the principle of diplomatic protection in order to represent its national, a country need to fulfill 2 prerequisites. Your Excellencies, the first prerequisites include the corporations or an individual should be a national of that particular country. Your Excellencies, the second prerequisites include that there should be exhaustion of all the available local remedies. Your Excellencies, moving to the first prerequisites, which is that Targaryen Power Corporation Limited is a national of United States of DGEF. Your Excellencies, in the case of Barcelona traction, it was clearly stated that in order to determine nationality, it must be governed that whether municipal laws are governing the functioning of a corporation or not. In the present case, Targaryen Power Corporation was established under DGEF, under the municipal laws of DGEF, which is DGEF Power Industry Restructuring Act. Your Excellencies, since the founding principle is the municipal law of United States of DGEF, and it's also governing the organization. Therefore, as per the Barcelona traction case, the guidelines which were established for establishing the nationality is successfully can be availed. Moving to the second concept in the nationality, Your Excellencies, which is about the principle of Sias Social and General Link, which was established in the case of Notebom, Liechtenstein versus Guatemala. Your Excellencies, in that particular case, it was established that apart from the effective nationality, a country need to establish a genuine link. Your Excellencies, in the present case, the very fact, the first para, third line of Moot proposition clearly state that Targaryen Power Corporation Limited is a leading supplier and innovator of 21st century. This establishes that a genuine link between the Targaryen Power Corporation and United States of DGEF. Your Excellencies, provided that both the principle established in the Notebom case as well as Barcelona traction case, the effective nationality along with as well as the nationality on the basis of genuine link is established in the present case. Provided that, Your Excellencies, since there is Targaryen Power Corporation is a national of United States of region, the first prerequisites required for principle of diplomatic protection is successfully fulfilled. We are moving to the second prerequisites in the present case, that is exhaustion of local remedies. Your Excellency, in order to avail the diplomatic protection, there need to be exhaustion of local remedies, as it was clearly stated in interhandle case. Your Excellency, provided that local remedies should be exhausted, but it should not be merely illusionary or notional in nature, rather should also effective in nature. As it was clearly stated in draft article on diplomatic protection, article 15.1, adopted in 58th International Law Commission report 2006, that the local remedies should be effective and must not be mere illusionary or notional in nature. Your Excellencies, in the present case, there was no effective judicial remedy available for the Targaryen Power Corporation Limited. In order to prove this point, the agent would like to draw your attention on the landmark case of Mushika Wabo and others versus Bharat Gas Reserve, in which United States of America decided, since the governments of Rwandan action was totally against the CDR party, it was decided that since not the only party, but the actions of the government of Rwanda was against the applicants, it was decided that the local courts are not reliable and incompetent. Considering the factor and the judgment, it was stated that the exception could be clearly applied in the Mushika Babu case. Your Excellency is considering the similarity of facts and the reasoning in the Mushika Babu case with the present case, because in the present case also, the government's action was totally discriminatory in nature, provided that it didn't provide the gas supply on time, didn't reply to the notice, and didn't complete the pipeline on time. Your Excellency, since the facts are similar with the Mushika Babu case, in the present case also, the exception to exhaustion of local remedies can be availed. Your Excellencies, in the present case, there is no effective judicial remedy available for the applicant Targaryen Power Corporation Limited. But Your Excellencies, this doesn't mean there is no other local remedy available. In the case of Electronica Secula, it was stated that local remedy doesn't only include the judicial court, but any competent tribunal. In the present case, the competent tribunal is arbitral proceeding, as it was clearly established in the redressal mechanism forum between the contract between TPO and white workers. Your Excellencies, in the present case, provided that the local remedy includes the local exhaustion of local remedy include the arbitral proceedings, it is also exhausted by the Targaryen Power Corporation Limited. Your Excellencies, to prove this, I would like to draw attention on the facts. On 10th April, when the gas allocation was stopped, an arbitration notice was issued. Based on that arbitration notice, an interministerial meeting was set up. But despite the positive report of the interministerial meeting regarding the allocation of the gas, the government didn't able to come on any conclusion. Your Excellency, since the output of whole interministerial meeting, which was a result of arbitration notice, not resulted in any significant result, it is clearly stated that in the present case, Targaryen Power Corporation has successfully exhausted the available arbitral proceedings, which is a part of local remedy. Your Excellencies, since both the prerequisites, which are that Targaryen Power Corporation is a national of DGEF, secondly, that there was exhaustion of local remedy in the present case and the exceptions to ELR will also apply, the principle of diplomatic protection can be successfully availed, and in the present case, the applicant party, the United States of DGEF, have ratione persona to adjudicate the present matter. If you don't have any further query, the Council would like to move its second submission under issue 1. May I proceed, Your Excellencies?
Yeah, sure.
Indeed, Your Excellencies. Your Excellency, the second submission, this Honorable Court has jurisdiction because the ratione matria falls under the ambit of this court. Your Excellency, in the present case, the principal agreement, that is comprehensive economic partnership agreement, which is binding the contract between white workers and Targaryen Power Corporation Limited, clearly established that it is established in the Moot proposition itself that it is duly registered under Article 102 of United Nations Charter. Your Excellency, since it is duly registered under Article 102 of UN Charter, relying on the case of maritime delimitation, the Pacific Ocean and Caribbean Sea, Costa Rica versus Nicaragua, and fisheries jurisdiction, which clearly displays that If an agreement or a treaty is registered under Article 102, it can be clearly inferred that they can exercise and ratify the jurisdiction of this honorable court. In the present case also, the principal agreement, which is Comprehensive Economic Partnership Agreement, is duly registered under Article 102 of UN Charter. Since it's registered under Article 102 of UN Charter, the applicant can successfully claim the jurisdiction under this code under Article 36, Para 1 of Statute of International Court of Justice. But in order to prove that, we need to prove that in the present matter, the contention and the subject matter falls under Comprehensive Economic Partnership Agreement. With that, I would like to proceed that how the present matter falls under Comprehensive Economic Partnership Agreement. Your Excellencies, in the present matter, there is a clear violation of Article 10.3, 10.4, 10.7 of Comprehensive Economic Partnership Agreement. Article 10.3, which talks about national treatment, Article 10.2, which talks about the minimum standard treatment, and Article 10.7, which talks about the transparency clause. Your Excellency, since the action was arbitrary and discriminatory, considering the gas wasn't supplied on time, due to which Targaryen Power Corporation suffered losses, not only the gas, but the pipeline work was also not completed by the TILA Gas Authority, due to which they suffered the major losses. Your Excellencies, since they suffered major losses because of the discriminatory action and their action was not fair and equitable and made arbitrary and discriminatory, it clearly violates Article 10.3 and 10.4, which talks about the equitable treatment. Your Excellency, Article 10.7 is clearly violated because it talks about the transparency clause. Article 10.2, subclause 2, talks clearly state that if a party raised an contention or clarification, the other party is bound to give the clarification for the same. But in the present case, on 10th April, when the gas allocation was stopped, on a notice issued by the Targaryen Power Corporation, neither the gas nor a reply has been given by the Union of TILA. In the absence of a reply, which they didn't abide by the rules set up in Article 10.7 of CEPA, hence there is a clear violation of Article 10.7. Your Excellency, since there is clear violation of Article 10.3, 10.4 and 10.7, we can clearly state the subject matter of this code falls under Comprehensive Economic Partnership Agreement. Your Excellency, since the subject matter falls under CEPA and CEPA is duly registered under Article 102 of UN Charter, therefore, the applicant can humbly seek the jurisdiction in front of this court because CEPA is duly registered under Article 102 under Article 36(1) of Statute of ICJ. Your Excellencies, if Your Excellencies do not have any question on the second submission, the company would like to proceed to the third and last submission under issue.
Please.
Indeed, Your Excellencies. Your Excellencies, the third submission under issue 1 is about the lex specialis, lex generalis, and parallelism of treaties. Your Excellencies, the present matter, it is clearly specified in the book of the Classic of International Law, Hugo Grotius, Chapter 14, Section 29, page 428, Para 2. Also, Digest of Justinian, Volume 4, that when the special law derogates from the general law, whenever there are more than one treaty or agreement governing the relation between two countries, the treaty which deals more specifically with the subject matter will be considered as lex specialis and will over or supersede the lex generalis, which is the treaty which governs the general nature of the agreement. Your Excellencies, in the present case, Comprehensive Economic Partnership Agreement is the principal treaty which is lex specialis, because it deals more specifically with the subject matter, which rules out with the investment related disputes, not only the investment related, but also trade related, and also sets up a specific dispute resolution mechanism under section C of Article 10.21 of Comprehensive Economic Partnership. Your Excellency, since CEPA deals more specifically with the subject matter in the present case, therefore it is the principal treaty which is lex specialis. Your Excellency, that doesn't mean in the present case the lex generalis is not abiding. The principle of parallelism of treaties clearly specified that under Article 30 of BCLT, Vienna Convention of Law of Treaties, if subsequent treaties governing the contract, then the treaty will be more specific in nature, general in nature, will only be used as for filling the possible lacunae of the lex specialis and dealing with technical issues and undefined terms of the lex specialis. In the present case, BIT will stand in the back as a lex generalis and lex specialis CEPA will supersede BIT. Your Excellency, the reason of quoting Lex Specialis SEPA is that SEPA is Lex Specialis superseding principal treaty, and this applicant humbly seek the jurisdiction under Comprehensive Economic Partnership Agreement only. With this, the agent would like to move to its second issue, which prima facie deals with the seat of arbitration at GEAC based in King's Landing as selected by TILA. Your Excellencies, the second issue which deals with this GEAC, there was no specific clause mentioned which should talk about the provisions regarding the seat of, in the absence of specific provisions or rules regarding the seat of arbitration, the respondent can't take an undue advantage of the particular situation and claim and select the seat of arbitration without the consent of the other party. Your Excellency, as it was established in the Taizhao court case, the Chinese court established that if in the year 2016, that if no specific provisions is provided for the seat of arbitration, then to give the right to select the seat of arbitration to the respondent will only create uncertainties in the arbitration agreement. Relying on the Taizhao court case, we can't give the right to select the seat of arbitration in the absence of any provision for the arbitration to the respondent, that is still running. We are moving to the first argument under the second submission, which is in the present case, the governing law, the Curia law, is unsettled model law on international commercial arbitration 1985, which is specifically mentioned in Moot proposition note point number 3. Your Excellency, in the present case, the governing law of the arbitration proceeding is unsettled law. Under Article 20 of unsettled law, clearly gives if no seat selected or no provisions for the seat selection of the seat, then the right to select the seat of arbitration will lie with the arbitration tribunal. Your Excellency, Article 20 clearly states, since the right to decide the seat of the arbitral tribunal, the respondent, by selecting the seat of arbitration by their own, doesn't rely and violated the Article 20 of unsettled model law. Your Excellencies, since the party has the right to choose the seat of arbitration under Article 20, now moving to the second submission. Your Excellencies, under Comprehensive Economic Partnership Agreement and Bilateral Investment Treaty, also the TILA didn't have any right to select the seat of arbitration. Your Excellencies, Article 14.3 of Comprehensive Economic Partnership Agreement clearly state that whenever there is a dispute, the right to decide the choice of forum will rely on the complaining party, which in the present case is the applicant. Hence, as per the 14.3 of SEPA also, the TILA has no right to select the seat of arbitration. Article 10 of BIT as well as Article 10 of SEPA, 10.21 of SEPA, which both clearly state that in case of any dispute, the unsettled model law will be obeyed and followed. And we already discussed, as argumented, that unsettled law, the right to decide the seat of arbitration would lie with the arbitral tribunal. Therefore, Article 10 of both BIT and SEPA also state that the TILA has no right to select arbitration, and the seat of arbitration will lie either with the arbitral tribunal or under the Article 14.3 with the complaining party. Your Excellency, third major argument, in the absence of any specific provisions for regarding the seat of arbitration, the substantive law must be looked upon. Your Excellencies, in the present case, the substantive law is UK's contract law, which is governing the contract. And it can be clearly drawn from the facts. Note point number 4, which is written that the UK's contract law is governing the present contract between the Targaryen Power Corporation and White Workers. Your Excellencies, since UK's contract law is governing, it is considered to be law in the present. Your Excellency, in the case of Balco judgment, it was clearly specified by the case when the choice of forum is missing, the substance will be looked upon for selecting the seat of arbitration. Since in the present case, the substantive law is of UK's contract law, in the present case, the seat can be selected on the basis of substantive law, which is the UK's law. That law also doesn't give any right to select the seat of arbitration to the respondent. Your Excellency, summarizing the whole argument, in the present case, TILA's action of selecting the seat of arbitration as GEAC based in King's Landing is not accepted because it is against this Article 14.3 of Comprehensive Economic Partnership Agreement, Article 10 of Bilateral Investment Treaty, Article 20 of Unsettled Model Law on International Commercial Arbitration, and against the substantive law as well. Under no, hence, the TILA has no legal right to select the seat of arbitration single-handedly without the consent of the other party, and the action of selecting the seat of GEAC based in King's Landing cannot be accepted in front of this honorable court. The council would like to submit issue 1 and issue 2 here.
Judges, do we have any questions?
Yeah, I do have. From
Sure.
your argument, it doesn't appear that the intention of the respondent was not to honor the contract. And because the intention was not clear whether they deliberately did not honor the contract or it was some compulsion. Number one. Number two, if that was the case, why did you directly go for arbitration? Why didn't you go for mutual negotiation? And before going for before coming to ICJ, you should have done your homework and done your mutual negotiation. Did you do that?
Indeed, Your Excellency. Thank you for the questions. Your Excellency is answering the first question, whether there was a deliberation in the contract or not. Your Excellency is the very fact that when the notice was sent in April by the Kargarin Power Corporation Limited, there was no reply came from the other party, the respondent party, which is Union of TILA. There is no reason in which they can't reply or clarify the notification issued. There is a clear violation of Article 10.7 of Transparency Clause, which shows that this is totally discriminatory and deliberate effect of respondent state in the present case. Moving to the second question, Your Excellencies, which is about the exhaustion of the local remedies by the arbitration proceedings about the amicable settlement of the dispute. Your Excellencies, on 10th April, when the gas allocation was stopped, an arbitration notice was issued by the TPO. As a result of that arbitration notice only, an interministerial meeting was set up. That was a part of amicable communication between both the parties. But what is the result of that amicable is not an effective output, because the interministerial committee's report being positive, but the consensus was not reached by the government of TILA. Your Excellency, since the amicable settlement dispute, which was practiced by the applicant TPO, doesn't lead to any effective output. In the light of doesn't effective output, it can be claimed that the amicable settlement can be exhausted in the present case.
One question. Hello. Am I audible? Listening me?
Yes, sir. Yes, sir. You're audible.
So here, is it a force? This situation, did it invoke for force majeure condition?
Team 304, you are not audible.
304A. Am I audible to you?
Yes, sir. Now you are.
Hello, audible? I'm just asking, is this situation a force majeure situation?
Indeed, Your Excellency. Force majeure clause is about issue which will be dealt by my co-agent in the subsequent meeting. With my permission of Your Excellencies, I would like to rest my case here and like to call my co-agent.
Okay.
Thank you.
Good morning, Your Excellencies. This is agent number 2. I'll be taking the third submission, which is that whether the force majeure clause can be invoked in the present case. Your Excellency, agent for the applicant state would like to mention a case of... Am I audible, Your Excellencies?
Go ahead.
Much obliged, Your Excellencies. Your Excellencies, in the case of Water Board versus Dickner Company, it was the court ruled that the situations under force majeure involves only the major delays, not the minor ones. Your Excellency, referring to the facts in the present case, there was a minor delay. Hence, it could not fall under the ambit of force majeure. Your Excellency, now the agent for the applicant state would like to mention the 5 conditions which are necessary to be fulfilled. Your Excellency, the source of these conditions is from Walter Culver's book named COVID-19 and Differences in Law. Your Excellency, Firstly, the first condition is that the event must be irresistible and unforeseeable. Secondly, that the event must be beyond the control of the parties. Thirdly, that the event must make it materially impossible to perform any contractual obligations. Fourthly, the estate must not have contributed to any such situations in any way. Fifthly, that the estate must not have assumed the risk of occurring such situation. Your Excellency, the agent for the applicant estate would like to quote here that that firstly, the COVID-19 was an irresistible event, no doubt. Secondly, that it was also beyond the control of the parties. However, Your Excellencies, it did not satisfy the third condition. That is, the event must make it materially impossible to perform any contractual obligation. Your Excellency, as it is evident from the correspondence on record that in the present case, the defaulting party, that is the Union of TILA hasn't performed the contractual obligation which can easily be performed in the present case. As example, as referring to the facts that replying the notice issued by the TPO seeking the gas supplies by the defaulting party, they failed to relying on the contractual obligation as it is mentioned in para 8 line number 1. Hence the case of impossibility relies here. For the legal backing of my argument, I would like to quote the article 10 cross 7 of CIPA, which states that each party shall upon request by the other party promptly respond to the specific question. Your Excellency, referring to the facts, the defaulting party failed to answer the question of the applicant state to seeking gas supplies. Your Excellency, now I would like to move towards the first sub issue, which is that there was no force majeure as per CIPA. Your Excellency, quoting the Article 10.16 Clause 2 of CIPA, talks about the remedy of what it is mentioned in Article 1. Your Excellency, Clause 2 of Article 10.16 talks about the waiving of that no party can waive of the contract if it does not have measures to perform contractual obligations. Here, inferring from this article, Your Excellency, it can be interpreted that if any party does not have measures to perform contractual obligation, it did not give right to any party to waive of the contract. Hence, Your Excellency, the force majeure clause cannot also be invoked in the present case under the particular article. Adding to this, in Article 10.18 of CIPA talks about to take the necessary steps. Your Excellency, the necessary steps to protect the life of plants, animals, and environmental concerns. Your Excellency, in the particular article, it only talks about the to take necessary steps. It does not have specifically mentioned about the to take the step that would fall under the ambit of force majeure. Your Excellency, now the question arises that in the situation of pandemic, was the invoking of force majeure falls under the ambit of necessary step? Your Excellency, arguing on that, the applicant believes that it's not a tangible and a reasonable step by the defaulting state to apply the force majeure clause in the particular case, as it is discriminatory in nature and it is based on the party's ignorance, due to which applicant's party has suffered much losses. Hence, inferring from this, the defaulting party also cannot invoke the force majeure clause as per Article 10.18 of CIPA. Your Excellency, moving to my further argument, that is there was no force majeure under BIT. Your Excellency, Article 10 clause 2 of BIT states that any party which is taking the steps to prevent the spread of disease cannot be prohibited in any way. Your Excellency, now I would like to quote that these steps have some conditions to follow. Your Excellency, the conditions firstly is that the step must be in accordance with the law. Secondly, that it must be normal and reasonable. Thirdly, that it must be non-discriminatory. Coming to my first argument, that it must be in accordance with the law. Your Excellency, the defaulting party does not comply with the contractual obligation and violated the Article 2 of BIT, which talks about the equitable treatment of each party in their respective state. Your Excellency, now coming to my second argument, that is non-discriminatory. Your Excellency, a step which is not in accordance with the law must not be non-discriminatory. It must be discriminatory and biased. Now coming to my third argument, that is normal and reasonable. Your Excellency, a step which is not in accordance with the law and is discriminatory and biased can never be normal and reasonable. Your Excellency, inferring from this, the agent for the applicant state would like to mention the condition which is making a law to an extent to avoid harm does not apply here, as the prerequisites which are required, that is, the step must be reasonable and non-discriminatory, does not fulfill. Hence, force majeure clause cannot be invoked. Your Excellency, now the agent for the applicant state would like to mention a case, that is Sidral Ghana Operation Limited versus Tulao Ghana. The question raised before the court was whether a party at default can rely on force majeure at terminating the contract. Your Excellency, here the court opined that if a party which does not comply to its contractual obligation could not invoke force majeure in any case. Your Excellency, there are two inferences which can be drawn from the above mentioned case. Firstly, that the burden of proof lies on the defaulting party, and secondly, if any party which does not comply to its contractual obligation can never invoke force majeure for termination of a contract. Your Excellency, now the agent would like to mention its third limb under the third issue, which is that there was no step taken for mitigating the force majeure event. Your Excellency, the agent for the applicant state would like to mention a case of National Oil Corporation versus Libyan Sun Oil Corporation, where the court opined that the defaulting state had not exhausted the available and approachable measures left to it. Your Excellency, this had made the contract frustrated and hence force majeure clause cannot be invoked. Your Excellency, in another case of Silverman versus Charmac Incorporation. Your Excellency, to clear the picture, in the case of Silverman versus Charmac Incorporation, the court opined that where one by his contract undertakes an obligation which is absolute, he is required to perform within the terms of the contractual obligation or answer in damages. Your Excellency, referring to the present case, here the defaulting party fails to comply with the contractual obligation and hence left with only one option, that is to answer in damages claimed by the applicant state. Here the council submits its argument. If Your Excellencies do have any questions, I would like to answer.
Judges, do we have any questions?
No.
Yes. Sorry. The chair was, sir, please, I will ask after that, sir.
No, I don't want. Kindly continue.
All right.
Please ask.
Thank you, sir. You yourself admitted that COVID-19 was a force majeure event, and it was not deliberate on the part of the respondent. So when you have admitted, then why didn't you resolve the case based on your contract, wherein force majeure issue was to be addressed, rather than coming to court and wasting its time? Why didn't you exhaust that clause? You yourself have admitted. Yes.
Your Excellency, on the exhaustion of the measures, I would like to mention that in para 8, line number 1 of the Moot memorial. Your Excellency, we have sent a notice, just a simple notice for seeking the gas supplies. Your Excellency, there was an interministerial meeting held in the defaulting state, which had recommended that the gas supply must be made to the applicant state. But there was no response from the side of Union of TILA government. Your Excellency, now we don't have any measures or approach to exhaust. So therefore, we have approached to the ICJ for seeking the justice.
Radhakrishnan sir, did you have a question?
No. Kindly continue.
If Your Excellencies do not have any further question, the agent for the applicant state would like to proceed with the prayer. Much obliged, Your Excellencies. Your Excellencies, the agent would like to proceed with the prayer. Wherefore, in light of issues raised, argument advanced, and authorities cited, it is most humbly prayed and implored before this honorable court that it may be pleased to hold adjudge and declare that, firstly, this honorable court has jurisdiction over the present investment-related arbitral dispute, and that the seat of arbitration should not lie in Global Energy Arbitration Center based in King's Landing. Also that, thirdly, the force majeure clause cannot be invoked in the present contract between TILA and DGM, and also pass any such order as the Honorable Court may deem fit in the light of equity, justice, and good conscience. Much obliged, Your Excellencies.
Honorable judges, if we do not have any questions, may we move forward with the arguments of Team 302? Thank you.
No question from my side.
Thank you.
No question.
No questions.
Team 302?
Yes.
Yes, you may begin with stating your time allotted, and you may begin with your arguments. Thank you.
The agent seeks permission to begin.
Can you please be louder?
The agent seeks permission to begin.
Permission granted.
Much obliged. If it may please the Honorable Court that the Council is appearing on behalf of the respondent in the matter of United States of DGEM versus the Union of TILA. The co-agent seeks permission to address the bench as Your Excellency.
Please go ahead.
Would Your Excellency like a brief pursual of fact, or shall the agent move directly to the arguments advance?
Sir, please brief.
Indeed, Your Excellency. Your Excellency, the background of the case traces back in the year 1996, when both the parties have entered into a bilateral agreement in order to make investment in the territories of contracting parties. Further, in the year 2009, there was another agreement which has been entered by the said parties, that was the Comprehensive Economic Agreement 2009. Next, the present matter in hand is, Your Excellency, that we all are aware of the ongoing pandemic across the world due to COVID-19. And because of the pandemic, there has been severe damages, not just to the economy, but as well as to the personal and public life of people. As a result of the ongoing pandemic, around 85,000 people have died at the present time. Your Excellency, because of the ongoing pandemic, there was an obligation upon the party to fulfill certain obligations which it could not adhere with because of the ongoing situation of pandemic, which made it impossible to perform. As a result of which, it could not supply the gas. As a result of which, the TPO, which is the investing company of the applicant state, has filed an arbitration against the present respondent state. So, for the said arbitration, the respondent state has suggested that they would go at the place in King's Landing, that is Global Energy Arbitration Center, to which the applicant state had said nothing but directly approached to the International Court of Justice. Your Excellency, if you have no doubt, shall the agent move to the arguments advance?
Sure.
Your Excellency, the agent will be speaking for next 25 minutes upon issue number 1. Your Excellency, there are total three issues, where issue number 1 and issue number 2 will be dealt by the present agent, and issue number 3 will be dealt by my co-agent. Your Excellency, the first issue states that whether the International Court of Justice has jurisdiction in the present matter. Your Excellency, to submit that, my brother counsel has very well argued to establish that the present applicant has access to the court, but has not established how they are validly competent to be present in the present court. Your Excellency, they have found jurisdiction under Article 36, Clause 1 of the statute. To read with, Your Excellency, please refer to citation number 2 on page number 15, which says that the jurisdiction of the court comprises all cases which the parties refer to it and all matters specially provided in any treaties and convention. So, Your Excellency, this present article provides for jurisdiction in on two grounds. First, there is a special agreement related jurisdiction. Second is treaty based jurisdiction. Your Excellency, there is no doubt that the present statute is open for the state, which gives it access. But the competency to be present in the present has to be derived from the Article 36. Now, Article 36 points out that there either has to be special agreement to come before it, or there has to be a treaty-based agreement to come before it. Now, the applicant state has stated that they have come under SEPA, which has referred them to this present court. There is no doubt that SEPA is registered under 102 of United Nations Charter Act. 102 gives membership to SEPA, but never says that they could approach to the present forum. Your Excellency, for approaching to the present forum under Article 36 Clause 1 for treaty-based agreement, they have to show that whether the treaty to which they have agreed upon or they have entered into, they mentions that if there is any dispute regarding the application of the treaty, they could approach to the International Court of Justice. Nowhere, neither in BIT nor in the SEPA, has it been mentioned that they could approach to the ICJ for resolution of arbitration related dispute, Your Excellency. Next, whenever a party is agreeing to a treaty-based jurisdiction, Your Excellency, they need to keep in mind that while exercising this jurisdiction, doctrine of specific subject matter and doctrine of presumption of confinement has to be applied, as has been stated by the present forum itself in the case of Morocco phosphate between Morocco and France. So, the doctrine of specific subject matter states that they have to approach to the present court in relation to that specific matter to which the jurisdiction has been set, because the treaty-based agreement gains its legitimation from the express consent of within from the party and not from without of the party. It is for each state. Each state has to decide that whether they want to come to the present forum, nor the other state could decide for one state, nor any international court could decide for the other state. Your Excellency, now they have relied their concern on lex specialis and lex generalis. Your Excellency, to mention that lex specialis means that the laws which is governing with specific subject matter. They said that SEPA is governing with specific subject matter related to the present dispute. Your Excellency, to bring to notice that the Article 13.1 of SEPA itself says that what are the matters to be dealt in with. It says that the matters are energy, textiles, leather, audiovisual, infrastructure, pharmaceutical, healthcare, tourism, and many more. So where is it mentioning specific that this particular issue has to be there, that this is a specific subject matter related to the present issue, because it is dealing with so many other subject matter. Second, it has said that under Article 14 of the same SEPA, it guarantees that the complaining party can come to a choice of forum which they choose. Now, the Article 13, which mentions also that what are the subject matter with which SEPA is dealing, it says the same Article 13 Clause 1(4) says that the application of Article 14 will not be on this particular chapter. Means chapter 13 is out of the purview of chapter 14. Therefore, the mention or the clauses of chapter 14 will not be applicable on chapter 13, where chapter 13 is the one which is dealing with the subject matter of the present issue, along with many other subject matters. That does not make the energy issue as a specific subject matter. Therefore, there is no application of lex specialis. To mention about that, your Excellency, as per paragraph 3 of the fact of the Moot proposition says that following the treaty, that is the bilateral treaty, TPU has made an investment in TILA. This specifies that the lex specialist is the bilateral treaty and not SEPA, because that is the treaty based on which the particular investment has been made. Therefore, Your Excellency, to mention that they are not qualified to come under the compromissory clause of the present statute of the code, because to come under the statute of the present code, they have to mention that how are they coming under which treaty it has been specified that they could come under the forum. As far as lex specialist and generalist is concerned, the lex specialist is the BIT, and nowhere it mentions that for choosing the seat of arbitration they could come here, or neither the lex specialist. It only mentioned that forum could be chosen by them, but just before that, the present chapter says that, previous chapter says that the chapter 14 will not be applicable into the subject matter of energy and many other matters. Therefore, application under 14 clause 1 cannot be validated, Your Excellency. Your Excellency, now the Council moves to the second ground on which it is basing that the present forum does not have jurisdiction. The second ground states that both the parties must be consenting before coming to the present forum. Your Excellency, it is a customary principle, and customary principle is something which cannot be violated with. And customary principle of ICJ has stated that from time immemorial, consensual nature of this particular platform is the basis for its jurisdiction, the prerequisite basis. Under the ration personnel is qualified, which only gives a membership that you can come to the court, but it does not specify that whether you have the capacity to argue in front of the court. Your Excellency, the argument that is both the parties must be having consent is based on two sub points. First, that states are sovereign entities, and second, that states first are sovereign entity, and second, that the necessity for compliance, Your Excellency. So first, that states are sovereign entities. To mention that every state in their territory is the highest authority and the highest power, and they cannot be subject to any other sovereign entity unless and until they consent for the same, Your Excellency. In the present matter, nowhere the respondent state has consented for the jurisdiction of the present ICJ. It has not mentioned that it want to resolve the dispute in the present, dispute that is related to seat of arbitration in the International Court of Justice. Also to mention, Your Excellency, the United Nations Charter, Article 2, Clause 1 itself says that the members, it says that, if you could refer to citation number 10, it says that the organization is based on the principle of sovereign equality of its members. So even if a party qualifies to be a member of United Nations, in order to approach to the present forum, it has to say that from where it is deriving deriving the competency of the jurisdiction. Either it has to be a treaty based, then the treaty must specifically say that they have to come in front of the court unless and until there is special agreement. Your Excellency, here is no special agreement, and therefore the party has never consented that it want to come. It has only come to the present forum to challenge the jurisdiction and has not consented. So the present forum is only for challenging the jurisdiction clause and not for any other purpose, Your Excellency. The second ground on which the sub issue is that, Your Excellency, that the necessity for compliance. Now, the need for consent could be understood on a pragmatic or a practical level as well, Your Excellency. We all know that international forum is a forum whose decisions are binding upon the parties. But, Your Excellency, the international forum lacks an international police force. That is, it has no sword and it cannot rely upon any executive or any administrative of any state for enforcement of its decision. So, Excellency, it is an intended or it is a continuous practice by various parties that they do not tend to abide by or comply with the decision of the court if it is against their interest, unless and until they have consented to it. So by forcing the parties to the present forum, what will happen? The parties will not be adhering to the decision. As a result, it will frame it will question the dignity of the present forum, which should not be done. As a result, for the necessity of compliance, the present forum should not accept the present jurisdiction, because the party have never consented to come in present forum or come before the present forum, Your Excellency. The last ground as to why this particular forum does not have jurisdiction is, Your Excellency, that the said applicant state has not exhausted all the remedies available. Your Excellency, to mention, exhaustion of local remedies, or the doctrine of exhaustion, is not a mere procedural act. It is a substantive act of international customary law. And in order to make it, and in order to come before in the present international forum, it is a mandate that there should be exhaustion of local remedies, Your Excellency. Now, this particular issue is based on another two sub-issues. First, that the exhaustion rule is under customary international law, and second, the same is available under the BIT, the SEPA, as well as the United Nations Charter Act. Your Excellency, one of the time-honored principles of customary international law has been that the national can espouse the claims, that the state can espouse the claim of its national only and only when the nationals have exhausted all its remedies available to them. Your Excellency, there is no doubt to the fact that the particular TPO has sent notice or has asked to confirm with the government of TILA. But all these exhaustion was done for the dispute which is related to the supply of gas. In the present situation, the dispute is related to seat of arbitration, for deciding where should be the seat of arbitration. This particular dispute has never been negotiated. The Taliban has said that it has suggested that it want to go for arbitration to a particular place, that is King's Landing. After that, the ICJ has never talked to the government or of Taliban that why it want to go and why it don't want to go, or has never negotiated as to what are other prospects or alternatives available for them to solve this issue. They directly has approached to the ICJ, and there is no exhaustion of local remedies as far as the present issue is concerned. That is the determination, the dispute related to determination of the seat of arbitration. In the present dispute, it is not disputed that whether there is monetary loss or the damages should be given, or whether there should be supply of gas. The only dispute is where should be the seat of arbitration, Your Excellency. Therefore, they have not exhausted the customary. Therefore, they have not exhausted the customary international law of exhaustion of local remedies in the present issue in hand. Your Excellency, the last sub-issue for the present issue is that the main governing articles, that is BIT, SEPA, and United Nations, all of the three mentions, BIT in Article 11, Clause 2 and 9, SEPA in Article 14, Clause 1, and United Nations under Article 33, Clause 1. All of it mentions that there has to be first the exhaustion of local remedies and then to come before the present forum. Your Excellency, the Council seeks permission to move to the next issue if Your Excellency has no question to the present issue.
Well, I have a question.
Yeah, indeed, Your Excellency.
You said they haven't exhausted all the local remedies, whereas the petitioner has said they have exhausted and they had served a notice to you also, but you did not respond to their notices. Secondly, when you were not able to adhere to the contractual agreement, you were not able to supply the gas. Did you serve a notice under force majeure to the petitioner? Over to you.
Indeed, Your Excellency, to address to your first issue, as the appellant state have argued that they have exhausted all the remedies. There is no doubt that they have sent notice to us regarding supply of gas. They have tried to talk to the government regarding supply of gas. After they have sent an arbitration notice, the present respondent state has replied and has even decided that they are willing to agree for arbitration by saying that they want the seat of arbitration at a certain place, that is King's Landing. But here the issue in the present forum is that what should be the or where should be the seat of arbitration. As far as this issue is concerned, they have never negotiated with us, Your Lordship, Your Excellency. They have directly approached. As soon as we have suggested, they have approached here without even clarifying with us that why they don't want this particular, without even clarifying that where else or what else should be a seat of arbitration. They are directly approached. So local remedy has not been exhausted as far as the seat of arbitration is concerned, Your Excellency. Your Excellency, the second question, that whether the force majeure clause, that particular issue will be dealt in the third issue, that is related to force majeure, and whether a notice has been served to them or whether a notice has not been served to them. Just to mention, Your Excellency, the government of TILA has at an international level declared that the present pandemic is a qualified event for force majeure. As has been mentioned in paragraph 10 of the fact sheet, Your Excellency. Excellency, the agent seeks permission to move to the next issue.
I don't know, my
Excellency,
fellow judges have any questions?
Your Excellency, the next issue is that the seat of whether the seat of arbitration should lie in the Global Energy Arbitration Center based in King's Landing. Your Excellency, the Council based this argument on 4 grounds that the present center has its jurisdiction. The first ground is that non-notification of King's Landing in the official gazette is not a qualified ground for invalidating the seat of arbitration of King's Landing. Second, that temporal application of a convention indicates the key importance to membership and not to the notification sent. And third, that the verbatim of the international law has to be read with the verbatim of the national law. And last, the requisites for formation of an arbitral panel. Your Excellency, the first ground, that the only ground on which the present applicant state is contending that the seat of arbitration should not be King's Landing is that the present government has not notified it into any of its official gazette. Your Excellency, to mention Article 10 of the bilateral treaty, which says that the agreement which has been entered or the investment which has been made under BIT has to be done in accordance with the BIT or in accordance with the laws of the contracting party, the host party. Here, the host party is, Your Lordship, the present respondent state, that is TILA. Now, therefore, the laws of TILA will be applicable. Your Excellency, that's why we are referring to the Arbitration and the Conciliation Act 1996 of TILA, where where section 44 of the said arbitration says that it lays that what can be foreign awards. For that, it lays 2 kinds of restrictions. First, award must consider any legal dispute, either contractual or verbal. Second, that the award must have been granted from any seat of arbitration which has been listed or which may be listed or notified in the official gazette. Your Excellency, here it is also mentioning the beginning of the paragraph starts with unless the context otherwise require. So this particular verbatim and phraseology it makes it evident that unless the context otherwise require means they are saying that if there are any other provisions other than this would be applicable and will not be, the foreign awards will not be limited to this particular 2 restrictions if there is something else available. Now, Excellency, the Council would like to move the attention towards the BIT Article 9 Clause 5, which says that the award which has been given any award which has been given by the tribunal will be binding on both the parties, and to this BIT the particular respondent state has agreed. Means if the reciprocity reservation does not come from section 44 of the Arbitration and Conciliation Act, but it is coming from the agreement itself. Therefore, as far as enforcement of the award is concerned, it will be enforced because the reciprocal reservation, it comes from another alternative, that is the BIT which has been agreed upon by the party. And therefore, notification is of no issue because even if notification is not done, because notification is only done for the purpose of enforcement, that the award should be enforced. So there is an alternative available. So there is an alternative available, and the alternative is that the BIT is also reserving the same reciprocity provision, that the parties, the award which will be granted will be a valid award, and therefore it will be a valid award, and therefore it will be enforced, and that's why the particular notification is not required. The second ground is that even if they consider notification to be so important to mention, Excellency, that even there have been various precedents, as if you could please refer to citation number 37, 38, and 39 on page 26, which says that important is that at the time of rendering, even if the membership is absent or notification is absent, it should be present at the time of enforcement. So when the award is granted, the enforcement will be done, and the notification may be given into a future event, even if it is not at the time of rendering, it will be given into a future event. So your Excellency, that's why notification is not important in the present case, because an alternative is available, as well as there is an option that in a future event at the time of enforcement, notification could be given. Your Excellency, the third issue is the verbatim of the section. The verbatim of the section 44 says that the notification may be given, and the same verbatim is followed under New York Convention under Article 1 Clause 3, that the notification may be given. So the word may specifies that there is a positive as well as a negative clause, that the notification is not an absolute mandate. It may be given, it may not be given. So only merely because there is an administrative delay, the act of administrative delay cannot neglect the whole provision of an international convention. And therefore, even if the notification is not given, there are provision how the particular award can be made enforceable, Your Excellency. Now, the last ground is that, Your Excellency, as the particular respondent state has stated that why it want to go to this particular center, that is the Global Energy Arbitration Center. And the only rejection which the applicant state, the only ground on which they are rejecting it is that notification is not been given. Your Excellency, to mention that this particular ground has been said that there is an alternative available to that. Now, Your Excellency, what is required to be done is that the formation of arbitral tribunal. Your Excellency, in many cases it is that if there is a lack of seat of arbitration, there is lack of arbitral tribunal. So the ad hoc arbitral tribunal appointed will be deciding any decision basing upon the place where the contract has taken place. Here the contract has taken place in India, and therefore the decision of India that whether it want to go to the arbitration center has to be taken into consonance, even if but there has to be certain negotiation or any other sort of settlement that why it should not go to that particular forum. The only ground they have contended is that it is not notified. To that we have an alternative. They don't have any other ground that why we should not go there. So that's why it is contended, Your Excellency, that it is said that the present forum wants to suggest that it want to go to this particular forum. It is not imposing this particular idea that they have to go to this particular forum. And as far as they want to go, they have justified that why they want to go, and the applicant states only contention that it is not notified has been made. An alternative solution to that has been shown, Your Excellency. And therefore, the council rests its issue and asks that if there is a question from Your Excellency.
Judges, do we have any questions for the respondents?
Now you can go ahead to next step.
Indeed, Your Excellency, the council rests the issue. Now invite the co-agent to refer to the last and the third issue.
Greetings, Your Excellency. This agent is appearing on behalf of the respondent, and I will be dealing with the third issue. The agent seeks permission to move forward with the issue.
Yes, permitted.
So the third issue is that the force majeure can be invoked in the present contract. It is most humbly submitted before this honorable court that force majeure can be invoked in the present contract, and I have based my argument on 5 grounds. First, force majeure can be construed from the SEPA. Second, COVID-19 has been declared as a force majeure event in the notification issued by the Union of Tilawin. Thirdly, COVID-19 is an extraordinary event which is beyond the control of the parties. Fourth, force majeure event has been invoked in cases of similar extraordinary circumstances. And the last is there is a supervening impossibility and change in circumstances due to COVID-19, and therefore the force majeure can be invoked in the present contract. Moving on with my first sub issue, that is force majeure can be construed from the SEPA. It is most humbly submitted before this honorable court that from Article 6.14 and Article 10.18 of the Comprehensive Economic Partnership Agreement between the United States of DGEF and Union of Tilawin, the force majeure can be construed. Your Excellency, I may state Article 6.14 and Article 10.16 of the SEPA, which states that nothing in this chapter shall be construed to prevent the adoption or enforcement by either party of measures that is necessary to protect public morals or to maintain public order. Your Excellency, here public order may be invoked by a party only when there is a genuine and sufficiently serious threat that is posed to the fundamental interest of the society. Your Excellency, here the essential interest is that of human life, and thereby force majeure has to be invoked in the present contract because it is a necessary measure which is taken to protect the life of the people. Secondly, it is necessary to protect the human, animal, or plant life or health. As I have stated, Your Excellency, it is a necessary measure that has to be taken for protecting the life of the people. Further, Article 10.16 states that nothing in this agreement shall be construed to prevent a party from adopting, maintaining, or enforcing any measure that is in public interest, such as the measures to meet health, safety, or environmental concern. It was a necessary measure that was taken to ensure the health, that was taken to ensure the lives of the people. Your Excellency, COVID-19 is a pandemic. It has been declared as a public health emergency of international concern, which is WHO's highest level of alarm. Your Excellency, the unprecedented nature of COVID-19 and the actions of the government around the world is indicative of the fact that it is a serious threat posed to the country. Therefore, Your Excellency, any measure that is taken by the government of Tilawin for protecting the interest of the society has to be exempted under the construed force majeure clause of the SEPA. Therefore, Your Excellency, the non-supply of fuel to the non-white workers owing to the restrictions and the worldwide shutdown is thereby excused under the force majeure clause. Also, Your Excellency, I would like you to see the fact sheet wherein it has been stated that the supply, paragraph 8, where it has been stated that the gas supplies, they have not been supplied since 10th April 2020, whereas the investment decision was taken in 2012. So, Your Excellency, there was no complaint regarding the supply of gas during this period. It was only after 10th April 2020 that the Union of Tilawin has failed to supply the gas, and that was because of the prevalent COVID-19 conditions. Your Excellency, you may also take note of para 7, line 4, line 1, which states that about 1.5 million people were infected and 85,000 people have lost their lives due to the pandemic by the first week of April 2020. So, Your Excellency, it was a necessary measure that has to be taken by the Union of Tilawin in order to protect the interest of the people and the lives of the people. Your Excellency, moving on to the second sub-issue, that is, there was a notification/memorandum issued by the Union of Tilawin declaring COVID-19 as a force majeure event. It is most humbly submitted before this honorable court that the Union of Tilawin took a necessary measure in order to prevent a further disruption in international commerce and trade by declaring COVID-19 as a force majeure event. Your Excellency, you may take note of citation 59, which states Article 10.10 clause 1 of BIT, which expressly provides that all investment shall be made with this agreement and in accordance with the laws in force in the territory of the contracting state in which such investments are made. Your Excellency, the investments here are made in the territory of Tilawin. Therefore, the memorandum or the notification that is issued by the Union of Tilawin that is expressly providing for the force majeure clause is applicable in the present case. Your Excellency, the notification further provides that it has to be considered as a natural calamity, and any delay has to be treated as a force majeure event on account of COVID-19. Your Excellency, this direction that has been issued by the government is also in accordance with the Electricity Act of 2003, which section 11 of the Electricity Act, which states that you may refer to citation number 60, which may states that the appropriate government may specify that a generating company shall in extraordinary circumstances operate and maintain any generating station in accordance with the directions of the government. Your Excellency, you may also look at the explanation where it has been provided that extraordinary circumstances mean circumstances arising out of threat to security of the state, public order, or a natural calamity. Your Excellency, COVID-19 has been declared as a natural calamity and as a pandemic by a WHO. Therefore, in the extraordinary circumstances of COVID-19, the generating companies, they are bound by this decision, by this notification of the Union of Tila, and they have to treat force majeure COVID-19 as a force majeure event. Your Excellency, now moving on to the next sub-issue, that is, force majeure can be invoked in the present contract as COVID-19 is an extraordinary event that is beyond the control of the parties. It is most humbly submitted, Your Excellency, that the force majeure event is one which is beyond the control of the parties and is not foreseeable. Your Excellency, before invoking force majeure or doctrine of frustration, it must be shown that the event which has caused the frustration was the one which the party to the contract did not foresee and could not have with reasonable diligence foreseen. Your Excellency, in the present case, both the parties to the contract could not have foreseen this COVID-19 pandemic which happened in the year 2020. Investment decision is based has been made in the year 2012, where no such situation was prevalent. Your Excellency, I would also like to state the three characteristics of a force majeure event that has been cited by the Colmar Court of Appeal. You may take note of citation 65, that any event may qualify as a force majeure event if it is beyond the control of the party, if it has not been reasonably unforeseeable, and if it must be unresistible. Your Excellency, in this the same court has also found that that a pandemic was not reasonably foreseeable at the time of the conclusion of the agreement, and the pandemic and its consequences, they were beyond the control of the party and they could not have been avoided by any appropriate measures. Your Excellency, these findings, they constitute a firm ruling that COVID-19, they fulfills the characteristics of a force majeure event, and thereby they constitute a force majeure event. Therefore, Your Excellency, COVID-19 is an irresistible, unforeseeable, and external event over which both the parties had no control, and it was a completely unforeseeable event. Your Excellency, the scale of the governmental measures that has been taken to tackle COVID-19 is unique and its extraordinary nature, and such measures has never been taken in the history. So, Your Excellency, this shows the extraordinary nature of COVID-19 and such measures which has made it impossible for the Union of Tila to fulfill its contractual obligations, as it has to fulfill the obligations of protecting the life and the interest of the people. Your Excellency, what is the main purpose of force majeure? That it is the main purpose of force majeure. It is to save the party from the performance of anything over which he has no control. The intention is to save the performing party from the consequences of anything over which he has no control. Your Excellency, in the present case, COVID-19 is something which was completely unprecedented, which was not foreseeable, over which both the parties had no control. So, Your Excellency, the intention of the force majeure is to save the non-performing, is to save the performing party from such an event. Thereby, the force majeure should be invoked in the present contract. Your Excellency, you may take note of citation 67 in the case of MS Halliburton of Offshore Services INC versus Vedanta Limited. It was held that the country-wide lockdown was prima facie in the nature of force majeure. Your Excellency, the shutdowns, the travel restrictions, and the everything that has been imposed in light of the COVID-19 pandemic has completely made it impossible for the Union of Tila to fulfill its obligation. Therefore, Your Excellency, COVID-19 fulfills the criteria of force majeure event, and the Union of Tila is not liable for the breach of the contract. Your Excellency, force majeure is a wider concept that also includes the act of the court. Under the UK law, it has been expressly held that act of God includes a pandemic or an epidemic. Your Excellency, COVID-19 has been declared as a pandemic. So, force majeure event will be covered in this present situation. Your Excellency, I would also like to cite the case of Lakeman versus Pollard. where the Supreme Court has held that the outbreak of cholera, it is an act of God, and therefore the laborers, they were not in a breach of contract, and the contract was discharged under law because of the force majeure clause. This pandemic situation is clearly within the wording of a force majeure clause. Therefore, in the present case, Your Excellency, where the Union of Telavan has failed to supply gas owing to the fact that COVID-19 has been declared a pandemic and such wide measures has been taken to protect the lives of the people, it would also fall within the force majeure clause. Your Excellency, I would like you to refer to citation number 73, which states that according to the draft article of the according to the articles on responsibility of states for internationally wrongful acts, Article 23.1, a state's responsibility for not acting in conformity with the international obligations will be precluded if such deviation is due to a force majeure event. Your Excellency, the force majeure event has been defined as the occurrence of an irresistible force or of an unforeseen event beyond the control of the state, making it materially impossible in the circumstances to perform the obligation. Your Excellency, in the present case, owing to the shutdowns, the restrictions, and everything that was imposed, it made it materially impossible for the Union of Telavan to fulfill this present obligation. Thereby, Your Excellency, the COVID-19 pandemic fulfills all the characteristics of a force majeure event. Your Excellency, I would also like to cite the International Chamber of Commerce, which issued an updated force majeure clause in March 2020 in response to the pandemic, and it stated that any event to classify as a force majeure event, it must be beyond the reasonable control of the party. Secondly, it could not have been reasonably be foreseen at the time of the contract conclusion, which is applicable in the present case, as the contract was concluded way back in 2012. And thirdly, is that the contract could not have been awarded or overcome by the affected party. In the present case, the social distancing rules and restrictions to non-business essential activities has made it impossible to perform the contract within the set period. Thereby, the force majeure clause is applicable in the present case. Now, moving on to my fourth sub-issue, force majeure has been invoked in similar extraordinary circumstances. Your Excellency, the Spanish influenza, it started in the year of 1918 and it lasted till 1920. It was prevalent for a year of almost 2 years. And during this outbreak, the legal experts, they have opined on the party's ability to rely on a force majeure clause. And as was stated in the case of Citrus Soap Company versus Petros Bros Manufacturing Company, it was stated that the quarantine, it sufficiently interfered with the plant operations to trigger a force majeure clause. And in this case, the suit for damages was dismissed on the ground that the event covers a force majeure, that the event comes within the meaning of a force majeure clause. Your economic effect of the Spanish influenza, as well as is similar to that of the COVID-19. The scenario during that time is synonymous to that of the COVID-19. Therefore, Your Excellency, COVID-19 qualifies as an force majeure event. Also, Your Excellency, I would like to cite some of the legal precedents that was stated when the situation of swine flu was prevalent in the country. You may refer to citation 77, wherein the Court of Appeals of Valencia has stated that an outbreak of swine flu, it falls within a clear case of force majeure, and citation 78, wherein the presiding judge has given the principle that before the declaration of the swine flu pandemic, that the World Health Organization had declared, which was unforeseeable and unavoidable, and which met the necessary requisites to consider that the resulting situation originated because of a force majeure event, they cannot be held liable for damages that may have been occasioned on the appellant's head. Your Excellency, the undeniable events due to a force majeure event being sudden and unanticipated here by the Union of Telavan clearly classifies to be a force majeure event. Your Excellency, the court cannot ignore the harshness of the situation in which the performance it becomes impossible by causes which was not foreseeable and which were beyond the control of the party. Therefore, Your Excellency, the COVID-19 it fulfills all the criteria and the force majeure shall be invoked in the present contract. Your Excellency, my last sub-issue is that it can be invoked in the present contract because there was a supervening impossibility and changes in the circumstances. Your Excellency, the theory of supervening impossibility arises when circumstances are such which makes the performance of the contract impossible in the manner and at the time contemplated for the performance. Your Excellency, in the present case, a nationwide lockdown imposed across the countries was completely beyond the control of the party. The supervening intervention of the pandemic made it difficult for the Union of Telavan Tillawin to fulfill its contractual obligation. Hence, force majeure can be invoked in the present case on the ground of supervening impossibility. Your Excellency, I want to cite the case of P. Mehra and Sons versus Ram Chandra Om Prakash, citation number 85, wherein the court has held that if there is an entirely unanticipated change of circumstances, Your Excellency, you may focus on the words entirely unanticipated change of circumstances. COVID-19 is an entirely unanticipated change of circumstances, which has affected the performance of the contract to such an extent as to make it virtually impossible or extremely difficult or hazardous. The change of such circumstances not having been brought by the default of either party, the court should not enforce the contract. And in the present case, Your Excellency, this COVID-19 was a completely, it was a completely unanticipated event, and it made it extremely difficult and also hazardous for the Union of Tillawin to go forward with to fulfill the contractual obligation, as everything was shut down. Your Excellency, it would be unjust to insist upon the performance of such a on the Union of Tillawin. Your Excellency, you may also take note that the public international law has recognized the principle of rebus sic stantibus, which is an implied term in every treaty, which states that it will cease to be binding when the facts and conditions on which they were based have fundamentally changed. Your Excellency, the investment decision was based on the healthy picture of 2012, taking into account the conditions and facts that was prevalent at that time, and not into account the pandemic situation. Your Excellency, this doctrine is a part of customary international law, and it has been provided in Article 62 of the Vienna Convention of Law of Treaties, and it helps to escape the principle of pacta sunt servanda. Your Excellency, the outbreak of COVID-19 has fundamentally altered the circumstances on which the contract was made, and the force majeure is thereby it can be invoked. Your Excellency, if you are satisfied with the issues, may I move on to the prayer?
Please.
Okay. Whereof in the lights of issues raised, argument for...
Yes. Hello.
Okay, yes.
Hello.
Yes, Your Excellency.
Yeah. You mentioned that this force measure is to be invoked here because this was an unprecedented event. But if you see in the force majeure clauses, you'll find that there is events such as earthquakes, flood, fire, but no pandemic kind of thing is mentioned. And if we talk about force majeure, at the same time there is a ESMA clause, that is Essential Services Maintenance Act, where you have to maintain the essential services like water, power. Whereas this gas supply to the plant, why it cannot be? Because it is to be invoked in the Essential Services Maintenance Act.
Yes,
Why are
yes,
they?
sure.
Yeah.
Yes, Your Excellency. So, Your Excellency, this measure was necessary for protection of the life of the people. I agree, power generation is an essential. It is an essential function, but that was ensured for the public. It was not supplying. All the operations was shut down only for protecting the interest of the society, for ensuring that the essential needs of the people are met. The supply of gas, like this essential management acts, which provide that electricity and supply of gas is an essential thing. But in the present, that is essential for the for the purpose of household, for the survival of people, and not for for the operation of any plant which is in the present case it is essential only. It has opened the plant, but only for supplying it to the public and not to any other investor country. And this obligation.
Let's sorry for that. Your contract is between power plant and the gas agency, and gas is to agency has to supply the gas to the power plant to run the power. And electricity is essential services which is needed for in the pandemic, for the hospitals, for the transport, essentials of transport. So how do you say that this is not under essential services? Gas is the basic ingredient to the power plant generation.
Your Excellency, I agree. It is an essential service, but that is an essential service that has to be ensured to the public at large. It is not for meeting the investors' requirement. This is an essential service for meeting the requirements of the people and not for the investors. And also, Your Excellency, you may take note that the SEPA itself provides that the contracting state where the investment was made, they can take any measure to protect the interest of the society. and it was a essential measure to protect the interest of the society. They were ensuring the supply to the people of their nation, because in this pandemic situation, everything was shut down. There was no import, there was no export. So whatever the country was having, they were ensuring it that every people in the country gets that. And after that, if they're left with something, they will provide it to the investors.
Okay.
I have a question. You have said that since the contract was made in 2012 and the notice was served to you in 2020, so have you supplied gas between 2012 and 2020 before invoking the force majeure clause?
Yes, Your Excellency. We have supplied the gas, and as you can see in the fact sheet, there has been no statement stating that we have failed to supply the gas. You can refer to the fact sheet. You can refer to the fact sheet wherein it has been stated the gas supplies have not been supplied since 10th April 2020. It has nowhere been mentioned that earlier the gas supply was disrupted or any failure was there on account of Union of Tilawan in supplying the gas. So it was only in this current pandemic situation that the Union of Tilawan has failed to supply the gas.
So, as you know, force majeure is a contractual provision contemplating an event which can result in deferment of the performance of contractual obligations, and therefore the parties thereunder such event continue and typically does not get excused absolutely from performing their obligation. So, what do you have to say on that?
Indeed, Your Excellency, they do not get excuse, but you cannot ignore the nature of COVID-19 pandemic. Such a pandemic which has taken the life of so many people, such a pandemic which is which has such detrimental effects on the entire country. You cannot ignore the nature, and such worldwide restrictions, such such ban on travels and exports, such bans on air flights and everything. It never happened in the history. So seeing the extraordinary nature, the court has to take it into account that the performance has become impossible because the government also has to fulfill its obligations towards the people. It cannot first see the investors' rights. It has to first fulfill the interests of the society, the lives of the people. It has to ensure that. And COVID-19 is such a situation which can spread. It's a virus that can spread just by standing near in front of you and in that situation. So we have to avoid crowd, we have to maintain quarantine, we have to do that. So such a situation is extremely extraordinary in nature and the party can be excused.
What was the effect of economy or manpower losses, etc., in your place? What was the effect of COVID-19? Was it like India, like US, like New Zealand, or like Brazil? What was the effect of COVID-19?
Your Excellency, the effect of COVID-19 was like India, and as the agreement that took place, it has to be parimetria. It is parimetria between the countries India and South Korea. The SEPA and the BIT that has been mentioned. The laws that is applicable in the present case, it has to be parimetria. So in the present scenario, we are taking it to be India, and the economy has it has been stated in paragraph 7, line 3, that the world economy had crippled due to the lockdown. Your Excellency, the entire world has suffered, and India, being a country with such a vast population, has suffered the most. Also, Your Excellency, with no vaccine in place, we cannot say anything right now, and so the operations which have been shut down owing to the fact that the lives of the people have to be protected is completely justified in the present case. Also, Your Excellency, you may note that the line 1 of paragraph 7, it states that about 1.5 million people were infected and 85,000 people lost their lives to the pandemic by the first week of April 2020. In the first week of 2020, this many people have lost their lives, and the economy has crippled very badly. Thank you, Your Excellency.
I have a question. You argued that whether it falls under force majeure event or not, but the petitioner has never contested that it is a force majeure event or not. They have always admitted that it's a force majeure event. But despite you falling under the category of essential services. You took advantage when government announced it as a force majeure event. You took advantage of that and took refuse of not honoring your contract, and you did not supply gas to the petitioner company. And it doesn't appear from your argument that it has actually prohibited you not to honor or not to discharge your duties. And you being a service provider for essential commodities, you have failed to honor that, and you have taken refuse of force majeure event. Secondly, the petitioner has not challenged whether it's a force majeure event. They have challenged you have not served any notice, or you have not responded to their notices of force majeure event. Over to you.
Yes, Your Excellency. Your Excellency, it is an essential service, but the essential services, they have to be first supplied to the domestic people, and not, it has not to be supplied for fulfilling some investment obligations that it has undertaken. It firstly must be supplied to ensure that the needs of the people, they're adequately met. And also, Your Excellency, this government notification has been issued in order to make it clear that this interruption in the supply has to be treated as a force majeure clause, and also to treat this delay as a force majeure event. Your Excellency, it is owing to the fact that in the first week of April, the COVID-19 situation was gaining momentum. So the government has to fulfill its obligations towards the people. It has to think of ways to protect the lives of the people. So at that particular moment, it was materially impossible for them to to fulfill their obligations. And also, Your Excellency, the point that you stated about they have not approached for force majeure clause, but they have contested that the minor delay cannot amount to force majeure, and which I refute, because any delay treated on account of COVID-19 has to be taken as a force majeure event. So if I'm not performing my obligation for a certain period of time, I can be excused and no damages can be claimed. Your Excellency, actually, the TPO has issued a notice of arbitration and demanded rupees 500 million in compensation of damages, as we have failed to perform, as the Union of the Lavin has failed to perform its obligation. So on that particular ground, I am arguing that we are not entitled to pay those damages, as the force majeure event is applicable in the present case. Thank you, Your Excellency.
All right.
Respected judges, if we do not have any further questions, can we move towards rebuttals?
Nothing from my side.
All right.
Okay.
Thank you. Team 304, can we start with the rebuttals?
Sure, ma'am. With the prior permission of Your Excellencies, the agent seeks permission to address the rebuttals. Your Excellencies, thank you, Your Excellencies. Your Excellencies, there are 4 major contentions in the present dispute. I will be dealing one by one with each of the dispute. The first question, which is raised from the respondent side, that there was no specific provisions or clause mentioned under SEPA and BIT in which it could ratify the court's jurisdiction. Your Excellencies, I would like to draw your attention on the case laws of Fisheries Jurisdiction, Spain versus USA, Maritime Delimitation Commission, Pacific Ocean and Caribbean Sea, Costa Rica versus Nicaragua. It was clearly stated that there need not to be specific provisions under a treaty or an agreement. The mere fact that a treaty or an agreement is registered under Article 102 is sufficient to ratify the jurisdiction under this code. In the present matter also, Your Excellencies, the SEPA is duly registered under Article 102 of UN Charter. Moreover, Your Excellencies, there is a wrong interpretation developed from the respondent side regarding the Article 102. They quoted that Article 102 is about the membership of United Nations. Your Excellencies, Article 102 is about the registration of treaties and ratification of treaties and agreement under UN Charter by its member states. Moreover, Your Excellencies, one of the major arguments they claim that we can't claim the jurisdiction under Article 36(1), and they incompletely and half read the Article 36(1). With the prior permission of Your Excellency, I would like to read full Article 36(1). Article 36(1) of the Statute of ICJ states that the jurisdiction of this court comprises all the cases which the party referred to it in all matters especially provided for in the Charter of United Nations. Your Excellencies, I would like to draw your attention on this point, which was ignored and half read from the respondent side. Especially provided for in the Charter of United Nations or in treaties and conventions. Your Excellencies, treaties and conventions can be possible approaches, but the approach through which we ratify the jurisdiction is the Charter of United Nations, since SEPA is registered under a UN Charter. Now, the question of consent which was raised by them doesn't fall in the present case, because since we approach in the present code under SEPA, and SEPA is mutually signed by both the parties, respondent and applicant in the present case, in the year 2009, an agreement which is mutually signed, the question of consent doesn't arise in that particular agreement. Your Excellencies, moving with the second issue, the major contentions raised by the applicant doesn't have any legal backing and doesn't provide that why there should be a legal right that TILA should choose the seat of arbitration. On the contrary to it, it is well established by the applicant that neither under the substantive law, which is UK's contract law, neither under the Curial law, which is unsettled model law in international commercial arbitration, neither under SEPA nor under BIT, any specific right has been given to respondent TILA to select the seat of arbitration. Rather, the seat of arbitration should only be decided, as mentioned in Article 20 of unsettled substantive law, SEPA and BIT, would be left with the arbitral tribunal, complaining party and UK's contract law. Under nowhere the respondent can claim any legal right under any provision in the mentioned laws to claim the right to set the seat of arbitration as GEAC based in King's Landing. Your Excellency, the second thing about the exhaustion of local remedies, the mere fact that after the issuance of the notice, there was no exact output or an effective output resulted due to non-consensus of the government authorities, established that the party need not to wait for resolving the query through the mutual amicable dispute settlement. Once there was no result of the local remedy, the party can claim the international arbitration proceedings and move forward. That is what the claim of the side applicant. Now, the major claims under the issue 3. Your Excellency, we never go into the discussion that whether force majeure clause is a pandemic is a force majeure clause or not. Whatever contention was, firstly, there was no specific mention of force majeure clause. In the present case, the substantive law is of UK's contract law, which clearly specifies that a force majeure clause can only be practiced or applied in case there is the mention of force majeure clause. In the present case, since there was no force majeure clause in the contract, neither in BIT nor in SEPA, the party can't claim the immunity under force majeure clause. Moreover, the essential commodity point was not very vague argument from their side. Your Excellencies, the mere fact that essential commodity is only for the investor, is not for investors, but only for the public health. Ultimately, the investors are the one which will use those fuel to create the electricity. And essential commodity is both equally important for investors, investments, and equally for the general public. In the light of the above rebuttals, the applicant humbly submits that the case relies on our side. Thank you, Your Excellencies.
Your Excellency, can I just take 30 seconds and state the prayer, please? And then we can start with the rebuttals. Okay, thank you, Your Excellency. Whereof, in the light of issue raised, arguments advanced, and authority cited, it is humbly submitted that this honorable court may graciously be pleased to adjudge and declare that the International Court of Justice has no jurisdiction in the present matter. The dispute of arbitration should lie in Global Energy Arbitration Center based in King's Landing, and the force majeure clause can be invoked in the present matter in the hand, and pass any other order, direction, or relief in favor of the respondent, which it deems fit in the interest of justice, equity, and good conscience, all of which is respectfully submit on behalf of the counsel of respondent. The counsel rests the case. Now we may start with the rebuttals.
Excellency, the agent seeks permission to address the rebuttals. Your Excellency, my brother counsel has mentioned that they have come under the provision that United Nations Charter give them the right to come under any specific dispute. Have United Nations Charter has nowhere mentioned that this particular dispute can be disputed as to ICJ has no jurisdiction in arbitration matter. This is a matter of arbitration, and nowhere in the United Nations Charter it's mentioned that arbitration matter can also be dealt as specifically seat of arbitration can be decided. The second issue they have stated was that in the present forum, the present forum do not has jurisdiction of the arbiter to conduct the arbitration at King's Landing. Your Excellency, it is to mention that at King's Landing, the proposal to conduct is not a mandatory proposal. It wants to, as the state fact says that the present respondent state wants to go there. So, even if it has some question that why we should not go there, it should be dealt through any arbitral panel, as has been mentioned in SEPA as well as BIT, and not directly to approach to the present forum. Neither a panel was formed nor it was negotiated, and directly they have approached without giving time to the respondent to respond to their idea that why they don't want to go, and want to clarify that why they don't want to go, to justify that why we want to go there. And they directly has approached to the ICJ, and it's never that we have mandated that we mandatory provision that we want to go there. It says that we have to go there. We say that we want to go there, as has been mentioned. This was the second query. As far as the query of force majeure is concerned, it will be dealt with my co-agent.
Your Excellency, my brother counsel contended that the UK contract law is applicable in the present case. But, Your Excellency, we cannot ignore the Indian Contract Act, which is also applicable in the present case, as Article 10 of the SEPA states that all the investment has to be in accordance with the laws in force in the contracting state in which the investments are made. So the section 56, which states the doctrine of frustration, it has an implied presence of force majeure in it. So we cannot ignore that, and we cannot ignore the fact that there was an impossibility in the performance. Also, Your Excellency, they stated about the Essential Management Services Act. First of all, my brother counsel has not at all contended this issue, and secondly, the Essential Services Act is basically to ensure the needs of the people. So, firstly, the country is obligated, the Union of Taiwan is obligated to meet the needs of the people, and then it will fulfill its international obligations. So here in the present case, Your Excellency, owing to the large worldwide restrictions, the shutdowns and everything, the first priority was to fulfill the needs of the public. That was interest to society, and not to fulfill any investment obligations. The agent submits the rebuttal.
One question, just a supplementary. 302A.
Yes, Your Excellency.
You are saying that Essential Maintenance Act only for the service at large. Then essential services, suppose somebody, electricity is dependent on the fuel, that is the gas. If you not supply the fuel, then the electricity, the power plant cannot fulfill the Essential Services Act. It is
Your
not from investment point of view. It is the input to be given to the power plant so that the power can be produced and the public can be served at a large. And then pandemic, the hospital, electricity in hospital is very prime critical input for survival of the people. And the power plant is dependent on you. How do you view it?
But Your Excellency, it has nowhere been mentioned that like only the white caucus has not been supplied with the with this gas. All the other places where it was essential to meet the needs of the people, the supply of gas has been maintained. It was only where the country has made investment decisions it has failed to supply gas, and that also it has failed to supply in the period where the COVID-19 was gaining momentum, because it has to supply this essential services to the domestic people at large, and also to the hospital services and all.
Excellency, the council would like to add one more point to this question, that as far as essential services is concerned, it is for the needs of domestic needs. It's not for the maintenance of profit of any investors in the particular contracting state. And as far as domestic needs is maintained, even every sovereign authority has its obligation more towards its people, that it has to fulfill, the sovereign authority has to fulfill its obligation towards its people first, and then look for the profit which has to be occurred. Profit cannot be made a major ground for essential services to be supplied to them.
Okay. Okay, thank you.
Thank you, Your Honor. Do we have any further questions from any of the dignitaries?
Not from my side.
Okay. Thank you so much.
No questions.
Thank you so much, ma'am. With this, we come to the conclusion of the proceedings, and both the parties have well represented their cases, and we wish them all the very best. I request the honorable judges to kindly share the score sheets. So we start with the award ceremony. Every day is a new beginning. Take a deep breath, smile, and start again. Good afternoon to all our dear esteemed judges, competing teams, and everyone present here with us today. I, Shraddha Mumaya, on behalf of the entire TILA team, extends a warm welcome to everyone who has gathered here for the award ceremony for TIMCEE 3, Trans-India Moot Court Competition on Energy and International Laws. It was an absolute pleasure to host each one of you for this competition and welcome you all to the award ceremony of the competition. Light and brightness has always been equated with positivity and motivation, is seen as the harbinger of good. To start us off on an auspicious note, we will now have the lamp lighting ceremony. Meanwhile, sir, I would like to request the teams who have participated, our finalists, to kindly share their experience over here. So may we start with team 302?
Good afternoon, everyone. It was really a very a wonderful experience. We got really new exposures. We came to know about TILA and how it has established and how it has indeed doing such great work. And we would love to work with TILA even further in future. And it was really a wonderful experience to moot here, and our mooting have actually been held very successful, by being a member of TILA, and to have a future reference with TILA. Thank you so much.
Thank you so much. Yes. So can we have our video for the lighting ceremony? Thank you so much. So I would like to take an introduction to all of us over here. Dr. Gopal Energy Foundation, which is a non-profit organization with the motto of Energy for All, focused on eradicating the blue pencil of energy poverty. Some of the flagship initiatives of DGEF are Global Energy Arbitration Center, New Delhi, TILA International Conference on Energy, and TILA International Moot Court Competition on Energy and Arbitration Laws. TILA is a corporate law firm specializing in energy laws and food laws. TILA is the world's largest law firm in energy sector, providing a range of legal services both inbound and outbound. TIMCEE. Coming down to TIMCEE, the competition that we are all witnessing today. TIMCEE is a competition specifically designed for all the law students, advocating our motto to make right to energy a fundamental right and a human right in the Universal Declaration of Human Rights. TILA Moot Court competition focuses on objective of spreading awareness regarding right to energy, foster industry, academic partnership, and develop employment opportunities for the legal enthusiasts. The competition gives the participants to engage in meaningful discourse with the distinguished judges from the courts and tribunals, professors of law, management, and engineering, members of Electricity Regulatory Commission. May I now invite Mr. Raj Singh Niranjan for the welcome address. I would like to introduce Mr. Raj Singh Niranjan, who is the Managing Partner of Trans India Law Associates, He is a global provider of legal solutions in the diverse field of wind, thermal, hydro, and solar energy, along with the distinguished expertise in corporate law. His services expand all over the India with 51 global leader partners and 9 international representative offices, including Bangladesh, South Korea, Poland, UAE. He is a distinguished author in key publications articulating the right to energy movement and a philanthropist. He has been a keynote speaker in internationally recognized conferences and many more. It is his exceptional vision and leadership that has led TILA to become the fastest growing Indian law firm in the world and also a legal advisor, former legal advisor to International Solar Alliance. May I now request such a visionary, Mr. Raj Singh Niranjan, to kindly address our audience today and enlighten us through his remarkable words. Sir, over to you.
Thank you, Shraddha. Thank you so much. And brilliant students, you all have done remarkably well and you all are winners in life. I look forward to working with all of you. And whenever you want to do internship in TILA, you all are most welcome. Each and every participant is welcome to do internship in TILA. You have to just apply and we will ensure whatever is the first slot available, we'll give you that first slot. So with this, I welcome His Excellency Honorable Dr. D. Radhakrishnan, Honorable Chairperson of Tripura Electricity Regulatory Commission. Thank you, sir, for being with us. I also welcome His Excellency Honorable Mr. Chaudhary, Member of Bihar Electricity Regulatory Commission. We are honored to have you here, sir. Dr. Rashi Gupta, who is a role model for all the women entrepreneurs across the world, not only in India. And she is popularly known as Battery Wali. And I think so, she was a pioneer in establishing a lithium-ion battery manufacturing facilities in India, state-of-the-art modern manufacturing facility. And energy revolution has a lot of components, and one component is energy storage, actually. I also, welcome Dr. Ashish Nandan. He is a renewable energy expert and has a long, visionary experience in this area. I welcome Mr. Deepak Dikshit for joining us. And he has, served almost all the leading companies as law officers and counsel and general counsel. Thank you so much for being here. Special mention may be made, and I welcome senior officer from Supreme Court cases, SCC, Mr. Kapoor. He has been well-wisher for all our 3 moot court competition. So Supreme Court cases has been partner, I think so from first day onwards, they have been our partner. And Mr. Sanjay Kapoor is a personal friend for last 20 years, because I remember when I organized a moot court competition in Delhi University, 2001. So, I had a chance meeting of to Mr. Sanjay Kapoor, and it was a first meeting, and I asked him that we are organizing an internal moot court competition. Can you please donate some books? And he was very gracious that it's almost 20 years, 2001. So he was very gracious to donate books for as an award for internal moot court competition of Delhi University. So thank you, Sanjay ji, for your special appearance. So let us come to the important aspect, actually. And that important aspect is right to energy. Mr. Ashish Nandan, thank you so much for being here. So let us discuss right to energy. We are the largest law firm in the world in energy sector. And 5 years back, Dr. Rajni, Dr. Gopal Prasad and Dr. Vijay Singh and myself and all the partners were sitting, and we said the society has given us a lot. What have we given back to the society? That was the question. And we said, let us do one important thing as a career, as a part of our life. Let us make it a part of our life. So we said, because we specialize in energy sector and food sector, let us identify the biggest challenge in the world in energy sector and start resolving it without blaming anyone. And as I have told you the story yesterday in judges briefing and in the students briefing, that we organized a conference, TILA International Conference on Energy, and we invited experts from across the world, Europe, Africa, North America, and asked them to identify the biggest challenge in the world. And as I have told you yesterday, they identified 3 challenges. First is 1.2 billion people across the world do not have access to electricity. We are blessed. Second challenge, which I told all of you, is that 3.2 billion people across the world do not have access to clean fuel to cook food. So mothers cook food using cow dung cakes and wood, and they inhale poisonous gases, and 5 million people every year die because of this problem. This is World Bank report. Third, I told all of you about energy poverty. So after my discussion with judges and students, very interesting and very important question was asked from one of the participants. He asked, कि sir, मैं तो ये सोचता था एनर्जी नहीं है ज्यादा प्रॉब्लम, क्लाइमेट चेंज इज द बिगर प्रॉब्लम. Okay, so and I totally agree with him. I said you are bang on to the right place. Climate change is the bigger problem, but energy is the solution. It is not the problem. Right to energy movement is the solution. I will give you very small example. 3.2 billion people across the world are using cow dung cake and wood to cook food. So every 3.2 billion people every week have to cut one tree per week. हर संडे को वो जाते हैं, एक पेड़ काट लेते हैं और 7 दिन खाना बनता है. I cannot tell all of them to stop cutting trees because they have to cook food. How can I stop them from cooking food? Because of your climate change problem, because of our climate change problem, I cannot stop them doing it. But if I do solarization of cooking food, if I provide clean cooking food to them, they will stop cutting trees. That is very important aspect of energy sector, and we all have to work on in this direction. Firstly. Secondly, every one of us is using petrol and diesel for our vehicles. Let us shift to electric vehicles, EV. Let us use renewable energy. So energy is a solution to the climate change. So whenever you are working in energy sector, and Dr. Rashi is laughing, but then this is true, Dr. Rashi. So energy is not a problem, energy is a solution. Just imagine one thing. I talk about right to energy. The motto of this competition is to make right to energy a fundamental right in all the constitution and to be included in the Universal Declaration of Human Rights. Just take an example of Delhi. There is a lot of pollution in Delhi. If every person, whether it is in Jhuggi Jhopdi or whether it is in some other place, he starts using cow dung cake and wood, what will happen to the pollution level in Delhi? So my view is that minimum amount of energy, access to energy should be available to each and every person, last person, as Mahatma Gandhi said. To cook food, to live a happy life, to live a dignified life, and it's a basic human right actually. Then judges are very enthusiastic. Judges one of the important judges, he also called me. And he discussed the same issue with me कि sir energy नहीं है, ये तो climate change बड़ी problem, and I agree fully what he was saying. And then we had this discussion. But since we have a limited time, it's an interesting topic, and we all will continuously discuss this topic and work towards making right to energy a fundamental right in all the constitution and involve it as a part of our life. We can do 2-3 things. I have given you examples. Solarization of cooking food, electric vehicles. Just next vehicle, whatever you buy, you should buy electric vehicles. Promote it. Even if it is costly, don't worry about it. Spend some money. You are blessed that you have electricity at your home. Utilize it. So with this, I once again congratulate the entire team for working too hard, and all the participants, all of whom who have assembled from entire South Asia. You have done tremendously well. Keep it up and move forward in life. And Shraddha, back to you. Thank you for giving me opportunity to speak.
Thank you so much for your ever inspiring words, sir. Now, I would like to take you through the journey of TIMCEE from our first edition, second edition to the TIMCEE that we have witnessed. So hold your hearts and let us walk across the journey. Thank you so much. What a journey it has been. Moving forward, we now have amongst us a great personality, Mr. Sanjay Kapoor, Vice President Marketing SEC Online, the man who has been consuming himself to light the society and to bring brighter future to our new generation in the legal fraternity. SEC Online is India's premier online legal research solution provider. Using the finest of technological innovation, they have pioneered law information database for making law easily accessible through the electronic medium. Our legal information database and search program is a proven source for quick retrieval of case law, statute law, notifications, and other legal materials, providing most reliable, comprehensive, and up-to-date legal information. So may we call upon Mr. Sanjay sir to say a few words of wisdom to our participants over here. Sanjay sir, do we have you? Yes.
Thank you so much, Shraddha. Thank you for your kind words. Well, I do not believe that I'm of that stature. We are just doing the same job what an oxygen supplier is doing to the hospital industry. So, as far as we are concerned, we are only helping the legal fraternity, all three, I think, the divisions, be it academics, be it judiciary, and be it the legal fraternity. We are the oxygen suppliers in the form of legal research material to all three stakeholders. So first, I like to, in fact, say a heartfelt thank you to Mr. Raj Singh Niranjan, who, in fact, I have seen his, I think, journey starting from 2001. The humble journey now has, I think, transformed into international, in fact, movement, and I'm very happy to be associated with that movement. It's actually, I'm speaking from my heart, and I also wish to say my heartfelt thanks to Dr. Rashi Gupta, Mr. R.K. Chaudhary, Dr. Radha Krishnan, and other distinguished guests and other judges who, in fact, have, uh, I think, taken out their valuable and precious time for this Moot Court competition. We greatly appreciate the initiative of Dr. Gopal Energy Foundation and TILA to hold such ongoing initiative and this movement of energy, right to energy. And we wholeheartedly support this as an organization, as a person. Our mind and heart is together to support this in coming years as well. This is a great thought. And I'm also elated now to, in fact, share the new normal challenges that, in fact, the academic arena which is facing at the moment. Most of the educational institutions and academic institutions have transformed almost immediately into an online education system. They are having online classes, they're having online, I think, seminars, and also now I think the institution like TILA have started supporting the requirements of the Moot course. So it's such a pleasant surprise. SSC Online was also into great fix in the month of March and April when everything went into lockdown, and in this new normal, we were not knowing what to do as a publisher. Uh, India's leadership position in many areas is undoubtedly, I think, proved, especially in the software development and other things. Now, I think there are several other areas in which we are emerging as a true leaders, and I'm proud to, I think, share this, that I think academic arena is making so many, I think, so many changes which is definitely leading us to, I think, a world class education system. Everything has become so transparent. We are actually completely online now. While I'm speaking with you, I think most of the students in my family and also in the family span India are attending online classes, appearing in online exams. All the evaluations are happening in this remote fashion. So, what can be a better example? We are actually so thankful that we were actually having certain things with us beforehand, the support of technology, support of the bandwidth, and support of, I think, the mindset of people, those who are ready to take on this challenge and convert this adversity into an opportunity. SSC Online was also having similar challenge because we present today about 100 publishers on our portal, and when there was no remote access which was available to hundreds of institutions in the country, we were actually into a fix how to reach out to those students. Uh, in the month of April, we started talking to different organizations. We actually spoke to the company called Remotex, and they actually supported our movement, and we have collaborated with them for giving the MyLoft arrangement to the students pan India. So 166 institutions we have already provided online access to SSC Online, Hein Online, and the other online databases taken by these institutions, because they were not having the IT infrastructure to provide this remote access to their students. And more than 25,000 students have started using this new technology called MyLoft in various I think districts of the country, across the country, in this new normal. And I'm sure we feel happy as an institution that this support will continue up to 31st of December. And I'm also very happy to announce that as SSC Online and our partner collaborators, namely ICLR of UK, Lawnet of Singapore, and Hein Online of US, they have all supported our movement till 31st of December 2020. All these resources are available for asking. So we will provide not just the content, we will also provide remote access. We will provide full support for the ongoing education and other purposes like moot courts. So everyone is welcome to come and contact us, and we will be more than happy to share these facilities to any organization, any institutions having some academic activities in progress. With this, I say my best wishes to the organization, TILA, and Dr. Gopal Energy Foundation for doing this fabulous work, and to all the other stakeholders, the judges, those who are associated with it, and the young learners who have participated in this moot court competition. My best wishes for the great future. And thank you once again, everyone, for supporting this movement. My best wishes.
Thank you so much, sir. Very, very inspiring. Now, let me introduce the magnificent dignitary who is Asia's most influential woman in renewable energy sector and also known as Battery Valley of India. She is a pioneer in India and advanced lithium batteries, bringing the world's smartest lithium battery to India. She has been working on women empowerment issues globally and advocates gender equality. She is a CBC chair for energy storage and smart energy, co-chair for India chapter at Cleantech Business Club. Not only that, she is a committee member with Bureau of Indian Standards, International Electrotechnical Commission, National Energy Storage Committee, FICCI, and an admired speaker on various forums energy storage. Ma'am, with this, you being the admired speaker, we would love to listen to you.
Well, thank you, Shraddha. Thank you, Rajji, for such a wonderful opportunity here. My respected dignitaries and my young, bright friends out here. It was a pleasure to be a part of this wonderful event organized by TILA, DGEF, and all the supporting organizations. With this event, our movement of right to energy has gone one step further. And with such young, brilliant minds contributing, I'm confident that very soon everyone will understand that right to energy is not just having an electricity connection. It is beyond that. We need to ensure that we are having clean, green, sustainable, stable energy provided to everyone at all times. Energy is the lifeline to everything today. And we all are privileged to have the access to this. And as nations develop, populations grow, technologies advance, the quantum of this energy needed will only increase. And if adequate steps are not taken for a sustainable, inclusive development of energy access for one and all, the time very soon will come when we will see more and more disputes arising out of energy access. Just like food, water, shelter are some of the important aspects for our human sustenance, same is with energy. It is high time that we now realize that we need to erase the line of energy poverty, use more clean and green energy, and treat energy as a fundamental right, not just to deal with the climate emergency, but also add value to human lives. Today, I was thrilled with the idea that we could light a lamp electronically in a video. I was actually not expecting that. So it was a different change I could see today, how the mindset has changed, how the era is transforming. And the best is I could see equality. I always talk of gender equality, and today in the finale, I could see equality. And that made me even happier. And both the teams were fantastic. Loved the way you guys have presented and done the work. And I look forward to the award ceremony to see who the actual winner, of the moot court competition is. But in my eyes, every one of you was fantastic. Thank you so much for giving me this opportunity.
Thank you so much, ma'am. Thank you so much for your valuable words. Now, moving forward, let me introduce to you the one who is the pioneer in setting up of the first NTPC supercritical unit in Sitpar and widely recognized for his expertise in steam turbine island. Not only that, he has immensely contributed in Make in India manufacturing program, but across also. Can we have a huge round of applause to Mr. R.K. Chaudhary, who is member of Bihar Regulatory Commissions. Sir, over to you.
Thank you. Honorable Dr. Radha Krishna, Chairman, Tripura Electricity Regulatory Commission, distinguished judges, Mr. Raj Singh Niranjan, the main organizer of this TIMCEE 3, the young law professionals, and the ladies and gentlemen. This is indeed a very nice initiative, and I really enjoyed connecting myself as a senior citizen to the young professional. And I really went back to my school and college days, and where I used to qualify for the quiz competitions for various levels, but I never had the opportunity to just participate. And this is my first time that I got this opportunity by your TILA organization to be a judge and see the performance finally adjust their merits. As far as the Mr. Niranjan mission is for right to energy or energy poverty or clean fuel to the cooking is definitely a very what do you say, the very highlights of the today in the entire world. But to see that we can't wait that we should have an act for right to energy or energy product poverty. You have to work. You have to communicate, much communicate that how to use it or make this right to energy, energy poverty and cooking gas through the RE and all these things. You have to start doing the conversion. As far as right to energy is concerned, see, if you look back 30 years before and today, and because of Saubhagya scheme by government of India, you will find that many of the households in the rural side also, they have been illuminated. But slowly, I'm sure that today it is partly being done by the renewable energies, partly by the fossil fuel power plants and hydel. But slowly it will be global. This RE will be globalized and it will be taken over. By 2032, there is a plan that around 40% would be power generation would be 40% by the RE and rest would be by other conventional methods. But at the same time, right to energy, we should also emphasize conservation of energy to conserve. Because in our electricity regulator, there is a talk that a lot of PPAs are standing idle and we are paying the fixed cost and there is no variable power requirement because of the RE. RE is a must-run condition. So our power purchase cost to the consumer is going up. So they say that why not to make the agriculture category and the below PPL categories and all other domestic lower level categories to free power or cheaper power. But making it cheaper or free power is basically we are asking them to consume more than what is required. And once you are consuming more energy, you are actually damaging the environment because the more energy, more CO2 emission, and the environment will damage. It's well and said that RE will take over. Once RE will take over fully, and it has a timeline. It is not that in one decades or 2 decades it will become fully RE. It will take some time. Although there is an international solar alliance, but it will take some time, some decades to be completely RE compatible. So we have to start conversing and try to give energy to every need to their extent, to their optimum use. And that's my mission. And at the end, I would thank Mr. Niranjan, the organizer, for inviting me and giving me this rare opportunity. Thank you very much.
Thank you so much, sir. Thank you so much for wonderful words. And I agree totally with you, sir. And we all have to put efforts and work hard to make it possible, sir. And sir, one more thing, because I was discussing the questions of the students, but then one of the judges also, it was an interesting discussion. Whenever we see, if you see, whenever we see Discovery Channel, and if a person is placed on an island alone, so first thing, if you ask the what is the basic necessities, everybody says roti, kapda, makan. These are the three basic necessities, not beyond that. This is the general parlance. But if you put somebody in, generally we see in Discovery Channels, if you put somebody in an island, first thing, sir, he searches for food. But the second thing is very important. He does not search for housing or clothes. He searches for fire. He searches for energy. तो इफेक्टिवली जो हम कहते हैं ना रोटी कपड़ा मकान, थ्री बेसिक है, गलत है ये सर. जो सही बेटर वर्जन ये है रोटी ऊर्जा कपड़ा मकान, ये होना चाहिए एक्चुअली. तो बेसिक नेसेसिटी ऑफ लाइफ इज रोटी ऊर्जा कपड़ा मकान, इन दैट सीक्वेंस. So thank you for wonderful thoughts, sir. Thank you so much. Shraddha, back to you.
Thank you so much, sir. Now I'm going to introduce to you an energy sector expert having specialization in renewable energy. Having been serving in regulatory policy and strategy for the last 15 years, having served at the premier institutions like the Central Electricity Regulatory Commission, world's largest renewable energy company, a graduate in physics and masters in management, and having additional postgraduate qualification in 4 different management streams. He is one of the pioneers of renewable energy certificate mechanism in India and continue to be serving the nation by serving in renewable energy for a better tomorrow. With this, I would like to request Mr. Ashish Nandan sir to kindly share some knowledge with our presentees of the ceremony. Over to you, sir.
First of all, thank you so much for your kind introduction. And Honorable Mr. Radhakrishnan, Honorable Mr. Chaudhary, Honorable Dr. Rashi Gupta, Mr. Deepak Dikshit, and respected distinguished guests, TILA organizers, and all my young friends. It is indeed a pleasure to be part of such a nice moot court competition, and I feel really elated. And it was a very challenging thing when I see these young minds with full of passion, energy, and delivering their best. It gives me a motivation to go back to school. And really it is, the young ignited minds when I see them, and they are trying to hone their skills. And I'm very happy to see that they are very successful in their endeavor. My good wishes to them. Whatever they do in future, I'm sure they will be a very good lawyers, very successful lawyers in days to come. But this I will give this good wishes with a pinch of salt as well. That when you are successful at the zenith of your career, don't forget to be a human being. Be compassionate, have some empathy as well. Because these are the things which will make you human, which will make you a good human being, a successful individual. Professionalism is important. But if you add little bit of empathy and human touch, then the flavor would be something different, which not only you, everyone close to you will savor that flavor. Right to energy. See, this word, which is the necessity, may appear as a fancy word. I had written a quotation a long time back that I love electricity, but its bill pinches me. which is right. But at the same time, this has become necessity. You know, energy is the backbone of economy, and having a energyless economy, you cannot imagine where we would land up. We have example of African countries. You know, countries like Burundi and Chad, they hardly have 10% of electricity. 10% people are having access to electricity. Forget about quality of electricity and quality of supply. Let us not get into that details. It would be really surprising. We are lucky that we have good quality of supply because we are living in urban cities. But if you go to rural India, Mahatma Gandhi said the real India lives in villages. So if you go see their hardship for energy, and then you will realize how much gracious, how much lucky you are. And then from that angle, that is why I said that add human touch, and then you will realize the necessity of electricity. I'm sure TILA is doing a good job. My good wishes to them as well. And I feel that with your endeavor, probably right to energy will be served, and everyone, we will not be energy starved, or we will not be energy poverty country. But unfortunately, everyone wants electricity, but no one wants electric pole at their doorstep. We have to come out of this kind of mindset, and together we can probably be able to make right to energy a success. Once again, thank you so much for giving me opportunity and rejuvenating this Sunday. I feel that I will be having a wonderful week ahead, and after a hectic week, it is really energizing, rejuvenating. My good wishes to TILA, my good wishes to young minds, ignited minds, and thank you to my fellow judges and distinguished guests. Thank you so much.
Thank you so much, sir. And I'm sure the pinch of salt that you have been adding will definitely get the minds on working. And this generation, which is going to be the future of tomorrow, will definitely strive towards it. Thank you once again. Further, we have a dignitary who has had exposure to ICC under the POSH Act. Not only he is handling the Indian Compliance Committee and reporting to the global sector, and was also a part of the landmark case of Metro Machinery Traders. Without wasting much time, I bring to you Mr. Deepak R. Dikshit as an Honorable Dignitary, Associate General Counsel, Biorad Laboratories Private Limited. Over to you, Deepak, sir.
Thanks, everyone. It was very extempore. So, but still, being a lawyer, I will try to cover up that thing. So, I would like to thank, and I'm not as educated as you all are on energy sector. I am privileged to have worked with Niranjan way back, 17 years back. So that was the journey when we started on energy. Post that, I ventured into different sectors, but nevertheless, this has been quite a wide arena where I had worked, and I feel that the gap of demand and supply in energy sector is going to be very soon taken up at an appropriate level. And I think because of the initiatives which are taken by leaders in this ecosystem of people like Raj and Ashish, I think this is going to be a reality soon. So with this, all the best wishes to these gentlemen and young budding lawyers. Thank you.
Thank you so much, sir. Now is the time that we move towards our dignitary that we have had. And I would like to welcome our chief guest, Dr. D. Radhakrishnan, sir, Chairperson, Tripura Electricity Regulatory Commission. He has been a lifetime member of the World Energy Council. He's given his valuable to the trivial to projects like 24/7 power supplies, tariff designs, and renewable energy. I would, with this, like to say that Sir has had 37 years of experience behind him in coal, oil, power, and renewable resources. Dr. Radhakrishnan is a well-known authority on every aspect of energy field. Someone who worked tirelessly for almost 37 years in power sector with both public and private entities. He has emerged as an expert in supply chain management, project management, and regulatory affairs. Sir he's regularly into writing on power sector policies in multiple languages, publications, besides speaking his mind at several public podiums on sensitive issues which are related to power tariff, design, and evolving regulatory regime. We welcome you, sir, and we would please request you to kindly share a few words of wisdom with us.
Thank you. Thank you. Raj is otherwise a good friend of mine, and just to share, we live very close by heart and by geographical locations also. We both hail from Madhya Pradesh. So his father-in-law is also a good friend of mine. But leaving aside that, what I am trying to tell you, whenever you people call me, I am always overwhelmed with the kind of the knowledge which the young people are carrying with us. We have not only a secured energy future, we have a secured life also. Today also, whenever the questions, the way the participations were participating, it was a total passion. And I am really thankful you people have called me up, and I am ready for a clean and cheap energy. Thank you. Thank you. Thank you.
Thank you so much, sir. It is pleasure. Yes.
Thank you so much for joining in. And Dr. Radhakrishnan has been expert, and Madam and his wife is also a renewable energy expert. So the blood runs through the family. And please thank Madam also. And it is wonderful, and it is a pleasure having you in this event, sir. Thank you so much for supporting the Right to Energy movement.
Thank you. Thank you, Raj. Thank you.
Thank you for your kind words, sir. With this, I request Dr. Radhakrishnan, sir, to kindly release the next Moot Court competition, the next Moot, which we are releasing right now. So the TILA International Moot Court competition on energy and international laws, that is TIMCEE 4, shall be held on the 1st and 2nd October 2021. In the presence of all the dignitaries, we are here showing you the presentation to have a glimpse of TIMCEE 4.
Okay.
TIMCEE has been a series of events.
Thank you.
With the motto and the mission to enlighten and to sensitize the law students regarding the right to energy movement. Roots of TIMCEE have been with the Dr. Gopal Energy Foundation and the knowledge partner Trans India Law Associates. So these are the dates and the eligibility.
Okay.
Here we release the moot problem in presence of all the dignitaries and our honorable chief guest, Dr. D. Radhakrishnan. The moot problem is also available on www.dgef.in. All the details pertaining to the registrations and the program plans is available on the website. Thank you so much. You may note down the contact details to contact further. You may register today. The registrations are open already. So what next is left on the agenda? Yes. What are we waiting for? It is so nice to see the faces of the students when they know what I'm talking about already. Are we ready? Can I hear something?
Yes, ma'am.
Yes, ma'am.
Yes,
No energy is left. Should we postpone this program to tomorrow? After 2 days of hard work, I don't see any energy left in you. Can I hear a louder yes?
Yes.
Yes, ma'am.
We are still so much energetic. Yes, ma'am.
Great. So this competition has been a remarkable experience for each one of us. I acknowledge every department and member of the organizing committee who have given in their best efforts to organize this competition and make it successful despite the challenges of conducting it online. I equally thank all our participants who have played it so well, who have participated so well, who have given their best, again, despite of the challenges of conducting it online. Further, I must mention that we are thrilled with enthusiasm of the participants that tremendously raised the standards of the competition, the argumentative skills and the legal knowledge that was reflected by all the teams. So without further spanner of time, I shall take this opportunity to announce all of those who are taking things away from this competition, apart from the learning and the experience that they have had. So, can we have the presentation now? Can we start with the Best Researcher Award? Can we have any guesses for the Best Researcher? You may unmute yourself. You may write in the chat box. Can we have any guesses for the Best Researcher Award?
Could we show the award?
306C. Okay, Adeep, I think let us say who the Best Researcher Award goes to.
Okay.
Team 301. A big round of applause to Shreya Tiwari of Symbiosis Law College, Noida. The Best Researcher Award goes to you. The Best Researcher Award gets a prize of USD $50 with a month of internship at TILA headquartered New Delhi. Congratulations once again.
Are you here? Are you here, Shreya?
Yes, sir. Thank you so much. Thank you so much.
Please say what you want to say, beta.
So I just want to say that it has been a very enriching experience and I'm happy to be a part of this competition and I really want to see it grow in future and I'll happily contribute. As you said that now we are lifetime ambassadors of Right to Energy, so I will take it forward.
Very good.
Thank you so much, Shreya. Next, let us go to the best mooter for TIMCEE 3. Who has the best mooter been?
Shall I show them?
304.
Adeep?
Yeah.
304, okay. The best part about Team 304, okay, so it is Team 302. The best mooter goes to Ms. Silky Kumari. Ms. Silky Kumari of National Law University of Studies and Research Law, Ranchi. She's bagged a prize of USD $50 and a month of internship at TILA headquartered New Delhi. Congratulations, Silky Kumari. Can we hear from you?
Yes, ma'am. Thank you so much. It has been, I'm really honored that out of so many teams who have performed so well and so amazingly, I have been honored with this. I'm really happy and I'm looking forward to be an ambassador with TILA. Thank you so much.
Thank you so much. So now, out of 8 teams, there were 4 and out of 4, there were 2. So the third prize, who receives a cash prize of USD $50 with internship at TILA, goes to, any guesses among the semi-finalists? I want you all to guess the third prize. Hurry up. Any guesses for the third prize? Yes? Okay, Adeep, it's time that we show that the third prize for TIMCEE 3 goes to Team 307. Do we have Team 307? Can we have the participants from Team 307? Yes. The team was represented by Habiba Monjur.
Yes, ma'am.
Mohammad Abdul Hassanat.
Yes, ma'am, we are here.
And Mohammad Tawidul Islam. Can we please hear from you guys?
Yes, ma'am. Thank you, ma'am. We are
Green University of Bangladesh.
Yes, ma'am. We are from Bangladesh, and we are very happy to participate on this competition. And most importantly, I want to admit that the right to energy is a completely new concept, and we hope we will participate in next year also. And thanks to you all, and it was a very nice experience. Thank you, ma'am.
Thank you. Anybody else from Green University of Bangladesh that would like to share their views?
One thing, and that we are the one
Your voice is echoing actually. Yes.
My name is Habiba Monjur from 317. I addressing that it was a first we are participating in Moot court competition, and it is great achievement for us to go forward and achieve the third place in the first Moot court competition from our part. So it is very much exciting for us, and it also for my university. Thank you, ma'am.
Thank you so much. It was amazing to have you participating in TIMCEE 3, and as said by your team, we'll look forward to host you in TIMCEE 4. Now, the second prize of TIMCEE 3 goes to Adib. Let's not make them wait more. Team 304, Lloyd Law College, represented by Abhishek Tripathi, Shivan Singh, and Anjali Singh.
Thank you so much, ma'am, for the honor.
Yes, can we hear from you?
Thank you so much, ma'am. It was a really healthy competitions. We faced really knowledgeable persons, not only in quarterfinals but also in the semis as well as finals. Was really good. There was a really good question from the judges end, and I'm looking really forward to the becoming as an ambassador for the promoting the energy, green energy throughout the country, throughout my friends as well as my colleges as well.
Thank you so much. So they have bagged a prize of USD $125 with free publication of DGEF and annual named Energy for All, having ISBN number and a 6-month subscription to SEC for 2 members from the team. Congratulations, team. Well deserved.
Thank you
so much, ma'am.
So now, I needless announce it, but then I have to. The first prize of TIMCEE Championship, who the champions are. The champions of this TILA International Moot Court competitions are team number yes, none other than Team 302. National University of Study and Research Law, Ranchi, represented by Silki Kumari, Shreya Srivastava, and Chaitanya Jain.
Excuse me, ma'am. It's Yukta Ambasta. The last.
Yukta Ambasta. Yes. I apologize for the change in the name. Yes, so congratulations. You have won a prize of USD $250 with a 100% scholarship for all team members for Electricity Laws Online Certificate course, which is awarded by Dr. Gopal Energy Foundation, and a year of free subscription for 2 members from your team. Can we hear from you?
Thank you so much, ma'am. It was a pleasure being honored by all the judges, and it was really a great experience for us.
Thank you. Any other member from the team who would like to share any words?
Congratulations from my side.
Thank you, sir.
So much, sir. It was
Thank you
pleasure
so much, sir.
doing everything, doing research on every point of law which we argued right now. It was a really exhaustive moot proposition, and we did our best.
Thank you so much.
Yes, thank you, ma'am. And it was really good to be and really great to be. And especially, I would like to thank my team members for their support and the team spirit we have shown. And yeah, that's like, thank you so much.
Thank you so much. So we still have a lot to give. All our participants out there. So participants, all the participants of TIMCEE 3 will get a scholarship of INR 5,000 for the arbitration certificate course being awarded by Dr. Gopal Energy Foundation. All of them have been winners in our eyes and in the eyes of all the judges that were here to judge your rounds. Always remember these lines, it's not whether you get knocked down, it's whether you get up. So with this inspiration, I wish you all the very best. And I request, Adip, are we ready with the participation certificates?
On behalf of Mrs. Deshraju, Rekha Deshraju, we should release it because she is an expert in renewable energy. Madam, you can say hi to everyone.
Hi.
She was a judge in TIMCEE 2 actually.
Yes, I very much remember. Very nice to see you, ma'am.
Okay, please go ahead, Shraddha.
Yes, so I would like to call upon the participants and I would request all of you to give them a big round of applause. So the participants that we had were from Symbiosis Law School, Noida, Ananya Dhawan and Aryan Rajpal. Round of applause. Unmute yourself, guys. Let the claps get pouring for all our participants. Thanks. Next, we have National University. Yes, National University of Study and Research in Law, Ranchi, Silki Kumari, Shreya Shivasta, and Yukta Ambasta. We have Ravindranath Tagore College, Chittorgarh, represented by Ms. Prachi Garg, Ms. Anamika Jain, and Ms. Chaitanya Jain. We have Lloyd Law College, Chaudhry Charan Singh University, Abhishek Tripathi, Shrivans Singh, and Anjali Singh. We have Indore Institute of Law, affiliated to DAVV Indore, Rishi Kumar Tripathi, Yashraj Singh Kanawat, and Siddharth Kumar. We have ICFI Law School, ICFI University, Dehradun, Muskan Dosar, Shishali Shruti, and Shriyam Nigam. We have Green University of Bangladesh, Habiba Monjur, Mohammad Abdul Hasanat, and Mohammad Tawhidul Islam. Last but not the least, we have Navada Vidhi Mahavidyalaya, Navada, Siddharth Raj, Kamal Kant Kumar, and Shrishti Rani. Congratulations, all the participants. All of you will be sent the e-certificates for your participations and all your prizes respectively to all the respective teams.
I want to say one thing, that whenever I used to attend moot court competition, I would get my permanent friends actually. So जब मैं जाता था moot court competition में जो 20 colleges के लोग आते थे, 8 colleges के लोग आते थे, वो हमेशा permanent friend होते थे because 2-3 days we used to spend time with each other, competing with each other. But then ultimately we used to have a lot of fun with each other also. And in this case, because it is an online system, let us replicate it. We have already created a group of students. You all can now, with your names, as of now it was confidential, you could have not told your name or college. Please share and introduce yourself to all other team members. You can as well be friends, good friends to each other, and meet each other and talk to each other. And this group will be intact in WhatsApp group. Maybe we'll make you some of you who are active admin, and you can take it forward and share knowledge with each other. And you can also share your experiences with each other. With this, before concluding, we can have only 2 persons who want to share any experiences from the team members can share. Then we can conclude and close the session actually. So if any one of you, especially researchers, I see, because researchers are silent workers, so they do a lot of hard work, they do everything, but then they are not recognized and seen because of several reasons. Actually, they are not visible. So if especially researchers or anyone else, if you want to say anything, please go ahead. This is your time actually. All the marks are open marks actually, and they are all calculated after this competition. From Monday onwards, you can all ask for the marks and they will be sent to you via mails. We will not disclose the college's name. It will be codes actually. We can ask the researchers to say anything. From maybe 301 researcher, is there? Is he there? Is he or she there?
Yes, sir, I'm here.
Yes. Please go ahead, beta. Tell your name now and college name and go ahead.
Sir, I'm Shreya Tiwari from Symbiosis Law School, Noida. So, as I already said, that it was a very enriching experience, and actually, I feel quite otherwise, as it's not that the researchers are hidden or anything, but actually, the entire team works because of the researcher. So, I think they're not hidden, and even while answering questions, like researchers always remain there and they help the participants, the speakers, to answer the questions. So I think they have a very important role to play, and we should not look at it like they are not as significant. So that's all, and I really liked the efforts of the other participants, and the winners are also deserving, and I'm happy to be a part of this moot court competition, and I definitely look forward to participating in this further. So thank you so much.
Super beta, very nice. Okay, 302 researchers, is he or she here?
Yes, sir, I'm present.
Yes, go ahead, beta. Tell your name and your college name.
So I'm Yukta Ambastra from National University of Study and Research in Law, Ranchi. It was a really great experience. I remember we woke up early in the morning and started researching and started framing arguments. We were like, I think from the last month, every conversation me and my teammates had was, did you get this case? Did you find this point of law? And so the whole journey, it was really very wonderful. I mean, we forgot that we are friends or we are from the same college or we have classes. We were so indulged and so engrossed in the moot proposition that nothing came in front of us. So I think everything was, it was fruitful at last. So I'm very proud of it.
Okay, all of you are a lifetime ambassador of Right to Energy movement also. 30303 researcher, is he here? Is he or she here? I don't see him. So 304, okay. 304 researcher is here. 305 researcher is here. 306 researcher. 307 researcher.
Yes, sir.
Okay, please go ahead.
Thank you so much for
share your name and college name and your experience.
Yes, I am from Bangladesh, Green University of Bangladesh. I had a great experience in this journey, and thank you so much, Team TILA and Gopal Energy Center. Thank you everyone for this competition.
Great to see you. Great to see you. Okay, 308 researcher is here.
Yes.
Yeah, Kavya, please go ahead. Please tell your name and your college name and any experience you want to share.
Yes, sir. My name is Srishti Dani. I am from the Navada Vidhi Mahavidyalaya. And sir, I got a very nice experience from the work with the TILA, and it's really a very hard work to prepare the preposition, and I got a very much experience from that. Thank you, sir.
Yeah, start working from today for the fourth competition. Now the moot preposition is out, so all of you can start working. And kudos to you for joining from Navada and all the places. Back to you, Shraddha. You can conclude.
Thank you so much, sir. Thank you so much, all the participants. It is through such achievements that we clearly are able to see the skill, high expectation, commitment of the members and the participants. These results have been the examples of what we have hoped from our delighted participants. Thank you so much. I would again like to say the man who moves a mountain begins by carrying away small stones. So moving forward, I would like to invite Ms. Archana Maharaj, Senior Associate Advocate of TILA, to propose a vote of thanks.
Okay, so very good afternoon to everybody. Thank you, Shraddha. Honorable Dr. D. Radhakrishnan, Chairperson, Tripura Electricity Regulatory Commission. Honorable Mr. R.K. Chaudhary, Chairperson, Bihar Electricity Regulatory Commission. Dr. Rashi Gupta, Managing Director, Vision Mechatronics. Dr. Ashish Nandan, Renewable Energy Expert. Mr. Deepak Dikshit, Associate General Counsel, BioRed Laboratories Private Limited. Ms. Shweta Sharma, Group Head Legal and Compliance, CK Birla Hospital, Mumbai. Mr. Vishal Jain, General Manager, Legal and Compliance, Magma HDI General Insurance Company Limited. And Mr. Winter, Principal, Legal Counsel, Huawei Telecommunication India Private Limited, and all our Honorable Judge who was part of TIMCEE 3. And our most valued invited guest. Ladies and gentlemen, it's my privilege to have been asked to propose a vote of thanks on this occasion. I, Archana Maharaj, Senior Associate Advocate at Trans India Law Associate, on behalf of entire team of Trans India Law Associate, our knowledge partner, and Dr. Gopal Energy Foundation, our organizer, extend a very hearty vote of thanks to all our honorable judges for gracing your important work and sharing with us your findings and opinions today, and made TILA Online International Moot Court Competition a grand success. I would also like to take this opportunity to place on record our hearty thanks to our managing partner, Shri Raj Singh Niranjan, and our joint managing partner, Dr. Rajni Patel, for the perfect logistic support and guidance they have extended to all of us to make the TIMCEE world best moot court competition on energy and international laws. And also for their contribution and support to make right to energy a fundamental right in all the constitution of the world. I would also like to thank Mr. Sanjay Kapoor, Senior Vice President, Marketing SEC Online, and I would also like to thank our partner Law Sikho. An event like this cannot happen overnight. The wheels start rolling weeks ago. It requires planning and a bird's eye for details. We have been fortunate enough to be backed by a team of very motivated and dedicated colleagues who know their job and are result-oriented. I also extend my thanks to our administrator, Mr. R.K. Tiwari, our moderator, our coordinator, and our bailiffs and volunteers for their enormous cooperation in the organization of this event. I cannot thank everyone enough for their involvement and their willingness to take on the completion of tasks beyond their comfort zone. Our honorable judges, ladies and gentlemen, once again, I want to state that we are all most grateful to all our honorable judges, our partners, our organizers, and our participants on this stage. Thank you for being with us. It's been a great pleasure. Thank you very much. Thank you so much, Shraddha, and all the very best to all the participants. Thank you, Shraddha. Over to you.
Thank you so much, Archana. With this, the last agenda of our event over here is we would like to show you a thank you video to thank all of us, the TIMCEE Dream Team that Mr. Raj Singh Niranjan had nicknamed it as. So, Adeep, can we have the video?
Yes, Shraddha.
thank you, everybody. Once again, we congratulate all the participants, all the winners of this TIMCEE. We heartily thank all our judges for being with us here today. We thank all the organizers. We thank you, Mr. Raj Singh Niranjan. We thank you, everybody. With this, I would like to sign off. Looking forward towards TIMCEE 4 and looking forward to meet all of you once again very soon. Thank you so much. Signing off.